further checkup. He was operated last month. He could not come today. I was only seeking for the next week. He will be returning back. Only for the.
केस कॉल आउट होने पर एडजर्न करते हैं।
एडजर्न
जब भी होता है केस कॉल आउट होने पर, दैट इज द प्रोसीजर ऑफ दिस कोर्ट। यू वांट एडजर्नमेंट और व्हाटएवर ग्राउंड, जब कॉल आउट होगा, नहीं तो वेकेशन के बाद जाए, नहीं तो वेकेशन के बाद जाए, नहीं तो वेकेशन के बाद जाएगा।
नहीं हम कह रहे थे कि सिर्फ नेक्स्ट वीक अभी गए हैं चेकअप के लिए, ही विल बी कमिंग बैक।
आपके अनुसार डेट नहीं पड़ेगा ना, आपको एडजर्नमेंट चाहिए, डेट मेरे अनुसार, राइट? आप रुक जाइए, फाइल आया नहीं है, नहीं तो फाइल देख के एडजर्न करिए।
ठीक है।
This case, item 80, Council 406 of 2023.
Yes, please. Yeah, responding करते हैं। अब ये petitioner, ये पहले से आप क्यों हाफ रहे हैं?
So exactly, I have to file some supplementary affidavit, and that is
Supplementary affidavit in which case?
Tomorrow listing court was 7 hours.
Mentioning time is over. आपको जो करना है आप यहाँ से करिए ना, आपको क्या मना किए हैं?
बस supplementary फाइल करने के अलावा।
तो आपको मना किए हैं, आप यहाँ these things we don't bother about it, okay? You can just talk to the court master, whatever you want to file, there is no problem. Unless there is an order that no affidavit will be accepted, there is no question. इतना हाफिए मत, शांति से बैठ जाइए थोड़ी देर, sit for some time. You have also given some written notes.
But I had given it on the first day.
Just
And I have given a compilation of this.
Is it yours?
Madam.
ये एक revised note चाहिए।
Yes, I have given the details of the
For responding,
and the
right?
exhibit.
कौन सा? ये दो रेस्पोंडेंट और ये किसका? ये नंबर 1 है और ये नंबर 2 है, रिवाइज। इसको टैप करें। Yes, Mr. Das, you have to argue. She has almost completed, I suppose.
Mr. Lordship permits me.
No, I have not completed. He has completed.
No, I have not.
नहीं, आप मेरिट पे तो आप शुरू किए थे, कोई बात नहीं, आपको जो अपना आर्गुमेंट करना है कर लीजिए, he will respond. मेरिट में he has not argued.
No, it is nothing.
He has not argued on merits actually. He was on technical point only. Yes, please continue your argument.
Yes. I have given the chart of the list of the dates as also the exhibit. Have you looked?
Exhibit 1.
Exhibit 1 is the page 91 of the list, second list. There is two lists in the Lord Court record. Second list, page 91, photocopy of the circular dated 22/1995. Can you see that?
That's right, we have seen that.
Huh? Yes.
You have placed it.
Yeah, huh.
Which is that exhibit which was not exhibited before that?
No, that is only that document, my lord.
Which one?
Which I was read on that day, that financial position annex.
Which is
exhibit W4.
W4 was not marked exhibit.
No. W4 dated 17th October 2008 has been marked.
Okay.
W4, exhibit W4, 17th October 2008.
Yes.
That is marked, and that is at page.
No. Which was that document you were referring on the last day?
That was not exhibited.
Which is that document? Have you referred it here?
No.
You have not referred that.
No. What is the exhibit that has been?
Oh.
I have not.
No. So whatever you are relying upon are the documents which were exhibited before.
Yes. And that chart has been given. Only those which are exhibited before the
Fair enough.
lower court.
Yes.
I want to place the first exhibit 1. Exhibit 1 is, my lord, at page 91 of the list, and 91 of the second list. That is my basis of the claim, my lord.
Yes.
That is 20th
Page number 91.
Page number 91 on the second list.
Yes.
There is 2 lists. I have given all the.
That's right.
Yes.
This is W2.
W2.
Then W1.
W1.
Yes.
And W1 is the 20th February 1995.
Yes.
That is before the scheme and before the retirement. It is for information. This is the circular. This is for information to all concerned that the employees who have retired will be retiring under the company's voluntary retirement scheme, will be entitled to wage revision, pay revision, benefits as and when the same is penalized. And on that basis, on that expectation, we accepted the VRS. And VRS was not named in the name of the VRS, but it is forced because the mines was to be closed. And my lord, kindly see last.
What is the date of closure of mine?
Closure of mines? Date of closure of mines? 97. This scheme has been closure of the mines. That is subsequently, and they took the VRS in 97, 98, 99, 2000 onwards.
No,
And the scheme is there. Voluntary
Date of closure of mine is very important.
Yes.
Whether this VRS is prior to closure of mine or after closure of mine.
No, not.
All the
May I assist in the
yes.
date structure?
Give me the date.
Exhibit 8 is with respect to one mine, that is Pathargora, that is dated 23/12/1999. And 8 and exhibit 9
2012 1999.
permission for closure.
Permission for closure.
And exhibit 9 is with respect to Mosavani mines, that is dated 1/10/1997.
1/10
1997.
1997.
That is after July 1997.
These are relating to closure.
Yes, that is the permission of application for seeking permission of.
So this document is prior to closure.
This
95.
document is yes, that I am arguing. That is exhibit 8.
Yes.
Exhibit 8 is the 23rd December 1999.
Yes.
That is an application seeking permission of the government for closure. Therefore, it is not the date of closure. That is the permission of closure.
So closure is subsequent to that.
Yes, subsequently. And there is no dispute that we are on roll when the circular was given, and that is much before the closure, much before the VRS. That 20th February 1995, exhibit 1. Then kindly turn to exhibit 2. That is also more clear, 19th March 1995. There was a mental preparation for the closure. That's why that in that circular contains that those who are retired on VRS. This has reference to. This has reference to EC circular dated 22/1995. That is exhibit 1 regarding payment of arrears regarding payment of arrears on account of the wage revision or pay revision to the employees retiring ordered companies via the scheme. Have you got
This
it?
has reference to your circular, W2.
I am reading W2.
Yes.
Yes.
This has reference to your circular number dated 22/1995.
That is earlier
Regarding
circular.
payment of arrears.
Yeah. That is earlier circular.
Yes,
That is
yes.
by them. Then kindly, it is clarified. Then it has been clarified that employees retiring under the company's VRA scheme, in addition to pay. Have you got it?
Yes, yes.
In addition to pay revision benefit, who will be entitled for VRS benefit based on benefits accrued of the wage revision and pay. Therefore, it has been again clarified that in addition to whatever benefit has been given, extra benefit, ex gratia payment, including the benefit in addition of the pay revision benefit. Therefore, we are entitled for the benefit, and on that understanding, we accept it. Then kindly turn exhibit W3 and exhibit W. Exhibit W3 and W11 is the same. That is the settlement.
W3.
W3. That is
W11 is the complete document, W3 is the selected.
You can just refer to the exhibit W11 then.
W3 kindly see that.
एक ही document है ना दोनों?
Ah,
It's the same document?
yes. So,
W11 is that page number?
W11 is page number 77.
That one is page number 162 to 173 of the second list.
Which is in the other document?
No, in the
No,
second
that is
list
same.
only.
Okay. 170?
162.
160. Okay. It's here.
Memorandum of settlement.
You are referring to which clause?
That is 1.3. Is that it? Sorry, not 1.3. I'm sorry. 11. It is 7. 11 कहाँ है बताना?
167 is 11.
11
Yes, kindly see that. That is a settlement on 19th April 2006. Memorandum of settlement arrived up under the 12(3) of the IT Act between the management of the Hindustan Copper Limited and the employees represented by the recognized union operating as different establishment of the company of the National Joint Committee for Corporation meeting held at New Delhi on 19th April 2006 before Chief Labour Commissioner Central. My submission it has statutory force and that is binding on the parties. That is a settlement matter. And now kindly turn, that is 19th April 2006.
Yes.
Yes. And the terms and kindly turn the next page. Next, but second
Which
page.
clause are you referring?
Yeah, 1O, terms of the settlement.
1O, scope and coverage.
Yes, scope and coverage. The settlement shall cover all the regular employees, workmen born in the role of the Hindustan Copper Limited, that is irrespective of mines, whatever may be, as on 1/11/97, subject to condition enumerated in 7.1 and 8.1 of the Memorandum of Settlement.
The period of settlement will be from 1/11/97 to 31/10/2007.
31/10/2007. Therefore, my lord, we are guided by that period, and both the parties are bound to follow the settlement one.
Then revised pay scale.
Yes, my lord. Treatment in the revised pay scale 7.0. Can it
4.0 is also there.
4.0.
The revised scale of pay with effect from 1/11/97.
4.0.
What is the fourth one?
And 4.0 is the revised scale of pay with effect from 1/11/97 will be as under.
So there is a provision for revised pay scale.
Yes, and the chart also given, and we are claiming that according to the chart, according to the notification, that is
So
exhibit
this
1.
chart, whatever has been given, has been paid to you?
No. We are
This chart has not been paid to you?
No, we are claiming that.
When you are
Even
claiming,
that is
just a
one-
moment, when you are claiming this, then under such circumstances, what was the occasion to refer to the earlier VRS? It is very much a part of the scheme itself.
Scheme itself, our demand is on the basis.
So
of the-
your entire claim is on the basis of this scheme, not on
scheme.
basis of any other circular.
No, that is circular also, in
So,
circular.
so this revised scale,
Yes.
whatever has been mentioned in the scheme,
Hmm.
you want certain more scale over and above this.
No, I am
This is
entitled.
not the scheme, this is the pay revision.
Eight minute.
This is
We
the-
are
Pay
in-
revision.
But this is
pay
a part of the scheme itself.
Yes.
No.
That is a part
This
of
is
the
settlement.
scheme.
Exhibit 11, your lordship.
Exhibit 11 is
11
the
is the
settlement.
wage settlement.
Wage settlement.
Wage settlement.
So that is wage settlement we are entitled to. Pay revision, that is the chart has been given, that the revised pay scale. We are demanding that pay scale, which has been. Therefore, our demand is on the basis of the exhibit 1, exhibit 2 and exhibit 11. And kindly consider the 7.0, fitment of the revised scale of pay.
Yes.
The fixation of pay in the revised scale of pay will be effective from 1/11/1997. However, this fixation will be notional from 1/11/1997 and actual payment would commence from 1/8/2004 in the revised scale of pay. Therefore, that also is very clearly narrated. We are demanding that benefit. And kindly turn the 8.1.
One more clarification here. Your date of acceptance of VRS is which date?
That is when the chart is there, that is 99 to 98 also. No?
Is it all prior to 2004 or it is after 2000?
No, 2000.
So prior to 2000.
Yes.
And as per this pay revision,
Yes.
this settlement, the monetary benefit will be paid from 1/8/2004.
Monetary benefit will be paid from, that is the fixation will be made.
Fixation will be there, but
Yes.
monetary benefit will be from 1/4.
Yes, that may be, because after fixation, whenever the payment will be made, and that payment has been made, all the executive and non-executive, those who are on the roll or retired under superannuation, on superannuation. We have been discriminated. And then kindly done Exhibit 4. That is dated 17th October 2008. One point is important to show. In that previous exhibit, it has been sent payment will be made 2004, actual payment. And that notification after 4 years from that day, that is 17th October 2008. Because the management,
This is exhibit number.
exhibit number W4.
Page 106 of second list.
106 of the second.
Yes.
The letter dated 17th October 2000. That is a letter. Previously, what I have shown before your lordship, that is the circular memo and settlement. Am I correct to say? Therefore, my submission that letter cannot supersede the rights and power under the settlement or on the basis of the two exhibits that is before your lordship. And exhibit W4, 17th October 2008, that is the letter of the Under Secretary to Government to General Manager, Hindustan Copper Complex. Payment of wages areas arising out of 97 pay fixation revision. I am directed to refer your letter dated 9/7/2008 on the above subject. That letter is not on record or exhibited. Subject to convey the approval of the government to the payment of required areas arising out of 1997 pay revision for the period from 1/1/1997 for executive and 1/11/97 for non-executive to 31/7/2002 to the existing employees, to those separated otherwise than PRS in 2 installments during the current financial year subject to availability of the surplus fund. There we have been separated a class of PRS, and they said that this benefit will be given, that is due from 1997. There is no dispute for that. Pay revision from 1997. It was to be paid from 2004. That is also not disputed. But 2008, that letter has been given. That benefit is to be given to the person, those who are enrolled on 1/1/1997 for executive and 1/11/1997 for non-executive. In the chart, both are executive and non-executive information. Then kindly turn the next annexure.
So executives were also covered under the idea.
Yes. Yes. And entire matter is covered by the Industrial Disputes Act. That's
No, I just wanted to know whether executives would also be covered under the idea Act.
executive. Those who are not workmen, they are not under covered by
So in your list, both executives and non-executives.
all are
So
workmen.
if there is an executive, how anybody can claim any relief under the idea Act?
No, kindly consider. Executive and non-executive, according to the plan, it has been classification or whatever may be. Both are the workmen. That's why the industrial dispute was raised, and that point was never raised that the executive is not the workman. How they did it, that relief has been given.
All right.
And kindly turn my lord at exhibit 4. 5.
Page number?
Page number. Exhibit. Yes, ma'am. Exhibit 5 is page number 129. Photocopy of the office memorandum.
129.
Second list.
So all are in the second list.
Sab usi mein. 129.
129.
Exhibit 5. Yes, what do you want to say here? This is the scheme.
Scheme, yes. That is the scheme. The exhibit 9 has to not be covered.
This is a clarification given by the government.
Yes, I am pressing that. Exhibit 5, that is dated 8 December 2000. Whether, may I kindly see the office of that voluntary retirement scheme, voluntary separation scheme for the employees of the public enterprises. Serial number 3, whether any areas of the ex gratia are to be paid to the in the event of pay revision being sanctioned subsequently to the voluntary separation, and the answer is ex gratia will be recalculated. We want only this, nothing more. Ex gratia will be recalculated on the basis of the revised pay scale and the difference to pay. Can you consider my case? That is my claim, and that has been clarified in the office memorandum dated 8 December 2000. Therefore, our case is guided
This is issued by the Ministry of Heavy Industries.
in this. That is
And there is
issued by
a
the
scheme.
Joint Secretary.
There is a scheme.
Scheme, yes, voluntary scheme. Yeah. We had a section 1/5. No, we had a scheme. Voluntary, yes, that is exhibit. Scheme नहीं है। scheme तो नहीं किया है। Hindustan Copper exhibit W7, kindly see that.
Page number?
Page number W7.
Page 143, second.
Yes, we are a scheme in the exhibit W5. But I
W
have read
5.
8/12/2000, that is the scheme.
W5 is just a clarification. It is not a scheme.
Entire scheme not been given. नहीं है. Exhibit 6 क्या? नहीं है.
That is only memorandum. In memorandum, only the clarification of the VRS scheme has been given.
Where is the scheme? You are claiming as per the scheme. Yes, amicus, voluntary VRS scheme has been exhibited.
Yes, it's different. देना पड़ेगा सब. Kindly consider my letter.
I forgot your name.
In the Hindustan Copper Complex, that is the Government of Enterprises contention. कितना exhibit 6.
Exhibit 6 is the one.
Annual report. That is not the annual report. That is annual report. And that has not been separately. This scheme has been done.
Separately means your entire claim is as per the scheme.
Yes, how it will be calculated, all things has been there. The irrigation of the employees of the yes, here
That is
part of the exhibit 5. That is a part of the exhibit 5.
Let us see page number, please.
Page number 3.
that is page is 129, not last page. Exhibit 5, starting from page 129.
Yes.
Second list, last page. That is a quantity of calculation.
It is only computation. VRS scheme has many terms and conditions.
Well, what they will get, that has been given in the enclosure. Kindly see that.
That is not the scheme.
That is a part of the scheme, and what application your lordship is correct.
Where is the scheme?
There is the scheme. In that it has been enclosed the VRS compensation under the.
This is regular computation. Where is the scheme? You are claiming under the scheme and that is not there.
What they will get, that has been given. Yes.
Madam, can
Yes, your lordship is correct to say that VRS would.
the scheme is not there. Award has been passed without the scheme.
My lord, there is an your lordship is correct to say that is the basis, therefore that ought to have been.
That is a basic document.
Exhibit, but that has not been exhibited by them also, but not by the workman, but voluntary returns.
Madam, now a question straight away on law. When you are seeking implementation of a VRS scheme,
No. I want. We have been separated from the company under the VRS scheme.
terms and conditions of VRS scheme is absolutely mandatory to look at.
But voluntary.
Because that itself has the force of law. You are referring to clarifications. Where is the scheme?
Consider what is needed, my lord. Exhibit W5 is all things mentioned. What they will get and voluntary retirement scheme, paisa hoga, all has been given there. I cannot.
So it was not required to be exhibited. Let us take it that it is not exhibited.
Yes.
Okay. Let us take it that it is
Yes,
not
yes.
exhibited. We will see the consequences.
Yes. Kindly see the W5.
Just a
Exhibit
moment.
W5. That is the subject, kindly see. 8 December 2000. Voluntary retirement scheme, voluntary separation scheme for the employees of the public enterprises. That is the scheme. It has not been annexed as a separate document, but the office memorandum so far the voluntary retirement and voluntary separation scheme is on record. That is exhibit W5. Kindly see that, my lord. That is 129 in the second list.
This is just guidelines, the parameters on the basis of which VRS
Yes,
could be formulated by PSU.
Yes,
So
yes,
VRS has to be formulated by the PSU,
Yes.
that is the Hindustan Copper Limited here. So that was the scheme which was under implementation.
Scheme has been implemented. I have no dispute for that. VRS has been given ex gratia payment, whatever required that has been paid to us. Dispute is only that whether we are entitled for the revised pay scale, which has been revised on 1/1997 pay revision, and it has been implemented for the executive from 1/11/97, non-executive from 1 year.
Now one last question.
Yes.
What was the date of VRS scheme
But that is
under which you have taken your voluntary retirement?
Yes.
What is the date of that scheme?
That is in the chart it itself been mentioned, that is one page from 180.
That one is the chart, not below.
That is in the chart and all things has been given. That
No,
is-
no, that is the date of VRS.
Yes.
It must be under the scheme.
Madam, kindly consider, here is without any scheme not possible. What your lordship say, 100% correct, what is the scheme? But scheme has not been, but the memorandum, so far the voluntary retirement scheme is on record, that is W5. W5 is the record in which it has been stated elaborately what benefit they will get, what will be the ex gratia payment, and how it will be, whether the ex gratia will be recalculated on the basis of the revised pay scale. That is the what will by which they will be guided. That is all things are record on December 19. I want to place that and kindly consider that the first page memorandum, the parameter on the basis of the which the VRS could be formulated on the PSU, public sector undertaking, for their employees have been spelled out in the department OM number dated 5/5/2000, and however there are certain points on which clarification has been solicited by the PSE as well as the Administrative Minister Department, and these points has been examined to the government, and this point as well as the clarification are given under. That is, after the clarification, after the discussion, that has been formulated that has been narrated in the office memorandum dated 8 December 2000. And in this paragraph 3, I have already placed ex gratia will be recalculated on the basis of the revised pay scale in the different BP. And that the question before your lordship also, before the presiding official, whether any areas of ex gratia are to be paid in the event of pay revision being sanctioned subsequent to voluntary separation. That is the exact point which is before your lordship, and that point was before the industrial tribunal. Reference is that page 35. And kindly turn the next page. All things are given there. Whether it is mandatory to introduce new VRS scheme or continue with the existing. Paragraph 15 of that chart.
Paragraph 15.
Yes, paragraph.
Whether it is mandatory.
Yes, madam. This new scheme has been introduced in supersession of the old scheme, and then kindly consider the whether the
You
12,
see 19
12.
also? 19 also.
Yes, madam, 12 also important.
Yes, 12.
12. Whether casual leave any encashment up to the date of the notification of the VRS of the actual date of relief of employees. CL may be encashed for pro rata basis up to the date of the relief of the employees. What will be the compensation payable in case where the balance of service left under superannuation is less than 250 days and sum of the salary and balance period is
This
less
has got
than-
no relevance.
Yes, not.
And
nine-
para 19 also.
Yes, 19. इधर है 19. 19 इधर है. और सब कुछ में इसे 19 कुछ नहीं है.
19 ऊपर है, पेज 130. सीक्वेंस में. para 19 देखिए.
maybe sir. अच्छा. Will national pay revision national pay revision from 1992 and 1997 be taken for computation of the VRS benefit? In the new VRS and VSS scheme, there is no scope of commutation of the ex gratia on national salary revision. That is the new VRS. will
आपका तो
then,
BRS 2001 में भी है ना, after this also.
but then it is contradictory. The
Contradictory. That is why BRS scheme is
question, no,
necessary.
kindly consider whether any areas of the exchequer are to be paid. दोनों का meaning अलग है. Whether any areas, serial number 3, whether any areas of exchequer are to be paid in the event of pay division being sanctioned subsequently to voluntary.
We have read it. You
Yes.
explained 19 also.
Yes, that will be contradictory if the meaning stand with that. Will notional pay division from 1992 be taken for commutation of BRS and
Computation.
that is the two meaning. Commutation at that time there is no question of that because on the BRS.
Madam, we are not in a state of discussion. We are in a state, you are relying upon a document. You have not filed your BRS scheme. You are relying upon a document and particular clause of that. If there is some contradiction with other clause, it is for you to clarify.
Yes, I am clarifying.
Yes.
Ex gratia will be recalculated on the basis of the revised pay scale. 3.
We have read it. We
Yes.
have understood it.
Yeah, and 19
3 is also very clear. 19 is also very
yes,
clear.
19
Yes.
is that in the new VRS BSS scheme, there is no scope of commutation of the ex gratia on national pay division. That is the 8 December 2000. Any new scheme has been introduced in that, it will be not paid.
You have taken BRS in 2001 also. Some of them.
But I have been, yes, we have been separated.
Under which scheme have you been separated? Whether it is prior to this, whether it is under the new scheme, or you are separated under the old scheme. Which is the scheme which is applicable to you? The old one or the new one?
Let us see. On that point, I cannot say without any basis, but our claim is covered by 3. And that is clarified in 19, that in the new VRS. So it is not clear in the award also, and I don't know whether.
Yes.
I have taken out this document from the ministry site itself.
No, we can't refer to
No, there
that.
are certain other clarifications in person.
We can't refer to anything which has not been placed on record. We will not refer to anything. There is in the website something must be in labor matters.
Was with respect to that serial 19 itself.
What I am just observing is that you are claiming something under a scheme and subsequent clarifications issued, and the scheme is not exhibit. We do not know under which scheme they have accepted. That is absolutely a necessary document. You will rely upon the clarifications and you will not place the main document. I just can't get it.
Well, the contention in between the two clauses is different, and I want to explain before your lordship, as your lordship. Ex gratia will be recalculated. What has been paid as an ex gratia, that will be recalculated on the basis of the revised pay scale 10. And 19 is that will national pay division from 92 to 97 be taken in computation of such and such?
92 to 97,
No,
92 and 97.
Sorry, 92 and 97. The new PRS scheme, there is no scope of computation of the ex gratia on the national.
Computation, not commutation.
Computation of the ex gratia on national salary division. That is the notional salary division and revised, recalculated on the basis of the revised pay scale is separate, because the paragraph 19 that
It assumes importance all the more because of the reason, as per one of the document, I don't remember which one, as per the settlement, the revision will be computed and the monetary benefit will be given only from the year 2004. Amongst all the persons, as I remember, that the persons have taken voluntary retirement in the year 2001, some of within 97 to 2001. Right? So that particular monetary benefit, if there was any pay revision, madam, please appreciate, if there are two persons, one is already on roll and other is not on roll. The person who is on roll will get the monetary benefit from 2004. And the person who has already retired will get the monetary benefit. prior to that
Yes,
date.
but because if the benefit of the revised pay scale has been given, it has been
Anyways, you
extended.
just continue
Yes,
and
it
just
has been implemented 2004. And kindly consider just one line. If the benefit has been given retrospective from 1197 and it is paid on 2004, then we are entitled for that benefit.
it is not paid. It will be the monetary benefit will be made available only from 2004. It means that there will be a revision, the calculations will be done, but no payment relating to the period prior to 1/1/2004.
To that effect, my answer is that the benefit has been extended to the executive, non-executive, those who are retired on superannuation on roll from 1997. That has been calculated, payment has been made in the 2004. Therefore, I want that calculation to be made.
This is
Yes.
the status of VRS and the status of a person who is normally attaining the age of superannuation are two different class altogether.
Yes, different class.
So there cannot be any discrimination between two distinct classes.
Kindly consider, if there is a memorandum that we will get the ex gratia payment from 1997, whether they can deny to get that benefit.
That is
Monetary
why
benefit has been-
we are looking at this memorandum
Yes.
only, which is self-contradictory to clause number 19.
Yes. And therefore, my lord, our claim is that ex gratia will be recalculated. What has been given, that has been, that to be recalculated on the basis of the revised
right,
pay
that's
scale from.
I have
and-
noted it.
Yes, and 1997 it will be implemented and actually payment has been made 2004. Therefore, and all the persons has given that and we are getting that benefit. We are wanting the trying for that benefit. And kindly consider the Exhibit 6 annual report. Those
Page number?
page number.
Page 134.
Yes, say clause 5, clause 8, kindly see that. Dispute forming part of the accounts. The pay revision of 8 clause 8 annual report. That is annual report 2006 to 2007. Pay revision, pay revision of the employees of the company has been made effect with the approval of the concerned minister with effect from 7/8/2000.
1/8/2004, opening the base data from 1/1/97 and 1/11/97
For executive and for the for non-executive respectively for the purpose of the fixation of pay the
the resulting liability amounting of rupees 180,210,000 for the period 1/8/2003 to 31/70/2004 has been accounted for in the current year as on extraordinary item. The issue of annual salary for the period from 1/1/1997 to 1/11/97 to 31/70/2003 is yet to be finalized and is subject to compliance of various formalities. In view of the situations, an amount of rupees 9,007,99,000 computed on the opposite basis for the said period has been considered.
therefore the benefit has been given from 1/1/97 and 1/11/97. Actual payment has been made 2000. And thereafter the memorandum of the corporation, that is 27/3/1980, Exhibit 7, at page 143 to 146 in the second list. Memorandum of agreement. There. 1.3 consider. Various discussion are held by the chairman HCL with representative of the recognized union and the national level leaders of affiliated union to jointly explore the modalities for arriving the all India waste settlement, which will cover workment of different projects and lead to uniformity of the wage structure and general terms and conditions of civil service of the workmen. It has jointly discussed that our representative for the recognized union at each project will represent.
You are reading Exhibit W7?
Yes.
It's the same document as Exhibit 11.
No, it is
No,
the wage
no.
revision of
It
1980.
is
Oh, 1980.
It has no relevance in this
You
case.
are referring to 2.0.
1.3.
1.3 is not there in the record.
Remember, Exhibit 7.
It is
That is
not there.
page 143 to 146.
143 to 146.
They have only exhibited selected part.
Yes. It is not there.
Onwards are there. Otherwise also this
2.0
document
is there and
11, 10 point something.
10 point something is there. This is not exhibited.
And
not
otherwise also it is of 1980.
It is not exhibited, madam. Please don't read anything which is not exhibited.
11.1 medical benefit to those who are entitled for that. Exhibit 8, can you see that? Exhibit 8 is page 153 in the second list.
Yes, 150. Exhibit 8.
Yes, and you see that application seeking permission. What is the date? That is very important. That is date is 23rd of December 1999. Therefore, all the persons, those who are before your lordship, workmen retired on VRS scheme after 23rd December 1999. Application seeking permission of the government for closure of the Pathar and Ondadi mines of the Hindustan Copper Complex under 23rd. That is the application for closure of the company. And kindly consider next page. देखो ये सब पेज दिया है ना. Next page, last part, 10 lines.
There are certain VRS that is dated 39/1998 also in the list. 98 का भी VRS है.
The permission 1990 से लिया है.
98 का भी VRS है.
That circular is
97 का भी VRS है इसमें, date of VRS. 97 का भी VRS है.
That may be on the basis of the 1197 111.
So therefore, madam, this
Yes,
particular,
yes,
it is so very important that this particular list, whatever was received, should have been exhibited. This list, because this list, whatever are the list of the employees, was never a part of the reference initially, right? Later on it came,
Yes.
which has different dates, right?
Yes.
It starts from 1997 also, 1997, 98, 99, 2000, 2001, different dates are there, right? So these are very material dates.
Okay.
Now this particular circular which you are relying upon, this is of the year 1999. People who have already taken VRS prior to 1999 are also there in the list.
It must be the VRS scheme was
We do not
started
know.
before that. Whatever may be, so far the list is concerned, my submission is that in the
We will come to that. We will hear them.
Yes, during the pendency and it was asked for and it has been given by the competent authority. Therefore, that is a part of the reference. That is my submission so far the workman is
yes,
concerned.
that
Yes, yes, madam. And that is the
This is Exhibit W8.
W8 in the
This is 23rd of December 99.
99. Yes.
Or show it from this that it was also applicable to those who have already taken VRS by
no,
this time.
I can't show that. But
So therefore,
I try to impress on that point. 23rd December का बाद जो लोग हुआ है उसको
तो कैसे segregate करेंगे हम लोग?
But that is the 99 का
हम
बाद
लोग यहाँ बैठ के segregate
workman
क्यों
का
करेंगे?
महिला है. That is one line judgment. Those who are
So there's a one line judgment नहीं हो सकता.
that is the one line conclusion on that point. Those who are given the VRS before the 1997, whether they are entitled for the benefit or not, or after that whether they are benefit or not. On the basis of the exhibit W8, I can say to that extent, and I cannot change the date of VRS as in the file matter. And in the next page, can you see in
This is
addition?
the application seeking closure.
Yes.
Okay.
That is the closure of the coal mine. Pathalgada and Korandi line. They are not in that.
So
all
these
the
persons
workmen-
were working in this Pathargoda and Korandi mines.
Mosabani
Rekha.
and Rekha project.
So you are not concerned with this?
They are all the parts of the HCL.
Madam, let her explain.
Yes.
If they were not working in Pathargoda and Korandi
Yes,
mines,
yes.
then they are
Then
not
it is
concerned
not
with that.
relevant.
It is irrelevant.
Yes. At most I can say in the page kindly consider कौन exhibit में है? all the mines are under the HCL, and what is under them there is a chart for that is exhibited. कितना page बताओ? And that is definitely they are not in the Pathargada and Korandi.
Exhibited.
Therefore, there is a probability that for the closure of the mines, one after one, they have got permission.
Chapter 2, Lord.
Page
Exhibit
कितना?
7. That one is page 143. Of second list, Lord. Chapter 2, 2.0. Scope and responsibilities. All the mines that has been comes under the purview of HCL has
No,
been
there is no doubt on that.
There
There is no doubt on that, but each mine's closure is a separate procedure.
Yes.
It does not mean that if one mine is closing, the entire HCL will
No,
close
they
down.
got permission each and every mine separately.
Separate.
Separately, that
Very
is
good.
not connected with the workman. That is not connected with the workman.
So this is not connected. Exhibit
And
9
there
is not connected to this workman.
But it is not disputed under the HCL. There are so many mines, and that was one after one it was closed. And then kindly consider the exhibit 9. Eight हो गया ना? Eight तो हो गया. नहीं, हमारा ये नहीं है. Exhibit 9 kindly see that. That is page 156 in the second list. That is for Mosaboni matter. That is related in our case. Exhibit W9. Page 156. Abel Rashid got it.
Yes, sir.
That is regarding application seeking permission of government to close up the Mosaboni mines regarding. That is in our case. And the last paragraph, as a result of the aforementioned factor of the company has been facing financial difficulties with such and such loss being accounted by the management if the Mosaboni mines are not closed down, loss making mines the jeopardies of the contesting submission. That is the reason has stated. And then the next page. Next page it has been
equivalent to 6 years salary of the
They also pleaded for retrenchment compensation.
No, that is not the PRS scheme that is applicable. That is applicable and
For 6 years salary.
6 years salary. It's gratia payment. And that is the benefit that has been given for the PRS. And then accepted W.
This is just
equivalent to 6 years salary. What will be?
this is just an application.
Permission.
This is seeking permission.
That is a grant of permission.
This is grant of permission, which says that it should be condition. The condition precedent is this retrenchment compensation is to be paid. The ex gratia for 6 years salary is to be paid to the employees.
That is the application seeking permission. Exhibit 9, W9, 156. Subject is that application seeking permission of the government for closure Mosaboni mines.
Yes.
And what is the reason for closure that has been explained and permission has been sought for. And what benefit will be given that has been narrated also. So far the VRS is concerned. Exhibit W10. First exhibit W8 is not concerned of the regarding the workman, concerned workman. Exhibit 9 is concerned for the workman, and W10 is page 158 photocopy of the letter dated 8/6/2001 of the director. That is the you are aware that the mining of other allied corporation of copper project has already been suspended and closure notice for closing down the entire project has already been displayed. Under these circumstances, the company is not in position to utilize your service. It has been therefore been decided to abolish the post held by you under regulations such and such as adopted by HCL with effect from 36/2001, on expiry of which you will stand terminated from the service of the company as per rule. Incidentally, the voluntary scheme in the company has been reopened. Can you consider that means it was there, after that it has been again reopened, that is the 2001. In case you apply for voluntary retirement before termination of your service, the same will be considered for acceptance. That exhibit is very important. That is dated 8/6/2001. Phase-wise PRS was given, permission was given, and in this letter that is specially stated that those who are not applied for the VRS, their service will be terminated. Therefore, my submission, the VRS, in the name of the VRS, is not their own opinion or prayer or request. That is, they are forced to accept the VRS, because if they are not accepted, that they will be terminated from their service, dismissed from their service. And that is the background. That's why we say the additional benefit, that the pay revision benefit which was to be given to us, that we are entitled for that, which they cannot deny to give that. And then can you consider the exhibit 10, 8/6/2000? No, it हो गया.
11 is the part of the
11 is the part of the W3, which I have placed.
All the exhibits have been placed?
Yes. And now my submission is this, that from the judgment itself, can you see, the judgment has been, none of the witnesses has been examined on behalf of the management and the workbook. And none of the documents has been filed by the management to controvert our demand or whatever may be. Therefore, according to law 1986 Supreme Court 132, if that is not rebutted by the management, which I have stated in the document have been exhibited and the statement has been made, that has been accepted by them.
So your entire claims to the admitted, they filed their written statement?
They have said that.
So they controverted it or they supported your case?
No, controverted, definitely controverted. But they have not given any evidence, and the document which I have produced, that has not been controverted. That is my submission. And paragraph 6 of the award, kindly see, that has been narrated. So paragraph 6 of the award, page 28.
Yes.
Last line. The sponsoring union further put before that, sponsoring union has not examined witness in support of its case, management also not given. That is another line. And say paragraph 6, the sponsoring union further put the following documents in support of the which was not as such and such. All the exhibit has been discussed herein, and that all has been exhibited. The management, paragraph 7, the management has neither examined any witness nor proved any document in support of the case. There is my submission in the law policy. It has not been controverted. And kindly consider the concerned workman, namely such and such, before the violation of the tripartite settlement. Paragraph 3, I am reading. Paragraph 8, I am reading. The concerned workman, namely such and such, submitted before the tribunal that it is a case of violation of the tripartite agreement between the employer. That is my case. The tripartite agreement is bindings on the party.
This tripartite agreement was exhibit?
Tripartite agreement is for photocopy memorandum, exhibit W3.
W3.
Yes.
Yes,
Copy
continue.
of the memorandum dated 2006. And
Or W11.
yes, 19/4/2006. He has submitted that the concerned workmen are demanding arrears, privilege and other benefit arising out of the agreement with compound interest and cost. He has submitted that the government of India had introduced VRS scheme for time to time, and the employees have taken voluntary retirement under those schemes. he has further argued that at the time of floating the said scheme, the pay revision was pending, which was brought in force in 1997 after the employees had retired voluntarily retired. And the revision of pay was done on the basis of the settlement on 1/1/1997 for executive and with effect from 1/12/1997. This date, two dates are important for non-executive. He has further submitted that a circular was issued on 22/201995, that is Exhibit 2, to the effect that those employees who are retired under the company's voluntary scheme would be entitled to wage revision. That is my demand. As and when the same would be finalized, and on 19/4/2006, that is my Lord W3 and W11 exhibit. 19/4/2006, the settlement was arrived and between the employees and the ACA and the union with regard to the division of pay. That is for the particular point, the division of pay scale on all regular employees born in that role on ACL 1/11/1997. All were on roll on 1/11/1997. And he has further stated in the wage settlement, it has been clearly mentioned that those who are on roll on 1/1/1997 are entitled to the benefit of the settlement. That is our demand and place. He has also submitted that in para 7.1 and 8.1 memorandum of settlement, which has been clearly mentioned regarding payment of revised wages. He has also argued that the employees who are on the roll on 1/11/97 cannot be discriminated and denied benefit of the settlement because they have subsequently sought voluntary retirement under the various schemes floated from 1/1/97. He has further argued that the such and such Datta, who was ex-senior accounts officer, has been granted the benefit of areas who are similarly placed. That is the discrimination point also raised in that award. And in place, and so the workmen are entitled for the payment of areas he has made, therefore passing an award in their favor. On the other hand, the learned lawyer of the management submitted that the concerned workman has taken VRS from the company of ACL, so they are not employees of the company. Has also argued that the concerned workman is not under the provision of the section 2A and 2A. He has also submitted that the Ministry of Mines, by letter dated 17/10/2008 and Exhibit 4, W4 has clearly provided that the payment of the residual areas arising out of 1997 pay revision period such and such is to be made for existing employee and to those separated otherwise than VRS in two installments. And it has submitted that the regular employees have not been paid full areas arising 97 wages. He has further submitted that the meeting dated such and such 16/4/2009, that is also exhibited for 264, exhibit 4. W4 convey that the consent of foregoing residual 1997 pay areas arising of the 1997 wage revision for the period from 1/11/97 to 30/11/99. He has also argued that the concerned workman was separated VRS due to closure of the mines, which I have said W11. So they are not entitled for the areas. Now the only point determination in the case findings is paragraph 11. Outset discussion in the 11 mentioned at the time of receiving the schedule of the reference list of the workmen that has been sent to us. Subsequently, the Ministry of Labour and Employment was requested to submit the list of the involved in this case. My submission that is a part of the reference, though it has been submitted after the reference. But during the proceeding, after the Ministry of Labour and Employment has submitted the list of the 414 ex-employees of the Hindustan Copper Limited, so the list of the ex-employer HCL is a part and parcel of the sequence that is submitted. And it is required to mention paragraph 13 can you see in the case neither this
You read para 12 also.
Yes, para 12. It is required to mention that all the concerned workmen are ex-employees of the Hindustan Copper Complex, Musabuni group of mines, and they are opted for voluntary retirement on different dates under the VRS announcement by the Government of India. Yes, that is, there is no dispute for that. In this case, neither the sponsoring union nor management has adduced any oral evidence. Now coming to the documentary evidence of the concerned workmen, it appears that the Exhibit 1, W1, the circular dated 22/1995 is shown that those who are hired under the company voluntary scheme will be entitled to the wages of the division and pay division. The Exhibit W2 is the circular dated 1995, which shows that the employees retiring from company's VRS scheme, in addition to pay, pay revision benefit will also entitle the VRS benefit. The exhibit W3 memorandum of settlement of 2006, in which under para 7.1 it is mentioned that the fixation of pay in the revised pay scale will be effective from 1/11/97 and actual payment. And I have explained that will be calculated by payment. The revised pay scale of the para 8.1 mentions that the matter of payment areas for the year and 2 year and modalities of the payment thereof will be discussed and decided separately, giving in view of the paying capacity of the company in consultation of the ministry. Administrative Ministry. The exhibit W4 is the letter dated 17/10/2008, in which it has been mentioned that the payment of residual arrears arising out of the 1997 pay revision for the period from 1/1/97 for executive and 1/11/97 for non-executive to 31/7/2002 to the existing employee and to those separated otherwise than on PRS. That is the distinction that was made by this letter. In 2 installments during the current fiscal year and subject to availability of the circular plan of exhibit W5 is an office. It has been narrated what is it is. And exhibit 5 is the VRS in the office memorandum Ministry of Heavy Industries and Public Enterprises, and that is applicable all undertaking. The exhibit W6 is the annual report of the HCL. The exhibit W7 is the memorandum of agreement dated 1998. The exhibit W8 is the application seeking permission of the closure to such Patadaga and such colliery. Is an application dated 1/10/1997 for seeking permission of the government of. It has been narrated, my lord, what is the exhibit. Exhibit 11 is the memorandum of settlement of 2006, in which it has been categorically mentioned para 1.10. It has been
So just a moment. Para 14 is basically the list of exhibits
yes.
and what all are the description
Yes.
of it. But the
Yes.
contents and the discussion on the basis of these exhibits
Yes.
should be there in the award. Where is it?
Yes, in the award. That is, I am reading the award.
No. We are just, you see, like exhibit 5,
Yes.
right?
Yes.
It says that exhibit 5 is an office memorandum of Ministry of Heavy Industries and Public Enterprises regarding voluntary retirement scheme, voluntary separation scheme
Yes.
for the employees of the public enterprises.
Yes.
What is the
Discussion.
relevance of this document?
Yes. Paragraph. Next paragraph.
Next para. Let us have a look
Yes.
at that. Yes.
Paragraph 15. What is on the basis?
What is the relevance of
Yes,
these
yes,
documents
yes.
is required to be discussed.
Yes.
When did it
After going through the, I will consider that page
Yes,
48.
para 15.
After going through the list of the workmen submitted by the Ministry of Labour and Employment, it appears that the date of VRS of the concerned workman is after 1/11/97. So all the workmen mentioned in the list are covered under the settlement dated 2006. Then paragraph 16. The management has brought notice to the tribunal of the letter dated 17/10/2008, that is W4, exhibit W4, in which mentioned that the payment of the residual arrears arising out of the 97 pay revision for the period from 1/1/97 for executive, 1/11/97 for non-executive, 2/31/7/2002 to the existing employees and those separated other than the VRS in 2 installments during the current fiscal year subject to availability. That is their case matter, the difference has been made. Their VRS employees are not entitled. Now 17. Now under para 1.4 under the heading scope and coverage of the memorandum of settlement dated 2006 W11. It has been categorically mentioned that the settlement will cover all the regular workmen born in the role of the Hindustan Copper Limited as on 1/11/97 and the concerned workman whose name as mentioned in the list attached in the schedule fired on roll service of the HCL on 1/11/1997. Therefore, there is a finding on what basis. So they are entitled for division of pay wages of the para 7.1 memorandum of the settlement. In view of such fact, the letter dated 17/10/2008, which is their basis, exhibit W4, in the contravention of the memorandum of settlement. That is the submission before your lordship that that letter is contrary to the settlement, and settlement has a statutory force that cannot be controverted by a letter or decision subsequently. Arrived between the employer and it is employee. Moreover, any letter which contravenes the memorandum of settlement is not binding on the concerned workman. My lord. we shall give the judgment to that effect. It is required to mention here the management has raised objection on the point of maintainability of the reference. I shall read the judgment so far reference is concerned. Whenever it has been referred, it is the duty of the tribunal to decide the matter. In case the order has been passed, that it will be taken into consideration at the time of final judgment. They objected, so far the maintenance. It is relevant to mention here, concerned workmen are employees of the Hindustan Copper. That point has been discussed in paragraph 18, and they had to voluntary retirement under the scheme of the Government of India, and they had not been paid the revised pay scale since March 1997 as per memorandum of settlement dated of 2006, and paragraph 18. And in view of such, the reference is maintainable, and they are workmen of the workman of the Hindustan Copper, after considering all the facts and circumstances of the case, tribunal finds that the whole that all the ex-employees of HCL, as per list received from the Ministry by the Ministry of Labour and Employment, Government of India, such and such Sujit Kumar, last 413 others who are separated under the BRS scheme due
Where is the discussion of Exhibit 5?
Exhibit 5.
This is dated 8th of December 2000.
Yes. Exhibit 5.
That clarification, that
Yes, is a
memorandum.
memorandum, and that is paragraph 14.
In view of such
14.
fact, letter is in contravention to the memorandum of settlement.
Yes.
That is a separate
Yeah,
one.
yes.
But Exhibit 5 is 2000.
Yes,
Exhibit 5 is of
Paragraph
the year
6.
2000.
Yeah.
So I just want to know where is the discussion of Exhibit 5 in the findings?
That is paragraph 4. 14.
No, that is just enlisting it.
Yes.
This is what I was saying, that
Madam-
Exhibit 5, they say that Exhibit 5 is this document. Where is the discussion of the relevance of Exhibit 5?
That is
That
not,
has not been discussed.
not been discussed, and it is not even required. Madam, kindly consider. They consider the exhibit W5 PRS is an office memorandum history of heavy industries such and such voluntary scheme for the employees of the public enterprises. He has accepted that is a public enterprise के लिए जो BRS scheme है, it is the notice. Nothing more is required because that is
No, you were referring to a clause, so I was just clause 3 you were referring, which was that is not discussed.
No.
What is the content of that document is also not discussed.
Yes, that has been
So that is
discussed
just the
as
heading.
Paragraph 6.
Just the heading. Exhibit 5.
Exhibit 6 में kindly
Exhibit 5 का बात कर.
5 Exhibit 5 के लिए page 48 डिस्कस किया है,
48 में रेफर किया है.
रेफर किया है. What मतलब kindly consider the industrial dispute of each and every document will be in
No, because you were heavily relying on that. So I was just
See,
wondering that whether they have considered that clause 3 of that particular Exhibit 5. There is no reliance in the award. There is no problem. You can still rely on that.
Yes, Exhibit 5 photocopy the office memorandum dated 8/12/2000 regarding voluntary retirement scheme. The scheme is not disputed, therefore it has not been separately, and that is not required. Even that cannot be vitiated the award which has been passed on the basis
That's
of the award. That is my submission. That is my submission.
Yes, Mr. Baskets.
And in support of my case, I want to show what the decision my attorney consider. The decision.
Give the citation.
Yes, ma'am. Yes, ma'am. That has been given the list also. 2008 AIR SCW 3996.
Para number.
Para number 16 and 18.
Kindly provide a copy.
The copy here. Pleadings of-
SCW नहीं आता है ना ऐसा.
copy दे दो. Pleadings of the parties and evidence produced relevant for determining real scope of dispute. Wording of the reference showing that the dispute was on regularization of the service and of contractual. Pleadings, however, showing that the code issued before the tribunal was with regard of the status of worker as employees of the principal. Award of tribunal holding worker as the employees principal employer and granting leave for regularization. Therefore, what is the real dispute? It is to be decided, and that has been decided by the labor court. And so far maintainability is concerned, that is the case of AIR 1970, page 82.
1970.
No, it is not that. AIR 1986, page 132.
1986.
Yes, AIR 1986.
Page 132.
Yes, Supreme
S3.
Court.
What is the ratio?
52. Sorry, 132. 132 is the.
पैरा नंबर बताइए.
I shall give that, madam. I'm sorry. I shall give that. And so far maintainability point is concerned. 156. And so far maintainability is concerned, I shall give that minor from there. 2002, volume 3, JCR 52,
Volume 2 JCR
page 52.
52. High Court.
High Court. That is the division bench. Paragraph 8. The apprehension of industrial disputes is condition precedent for making a reference. Once a serious industrial dispute is referred to the labor court or tribunal for adjudication, then it becomes secondary whether the dispute was referred at the instance of the valid recognized union. For that reason, the labor court has been debarred from examining the validity of the reference. In this connection, reference may be made to decision to the Supreme Court. In the case of National Industry Union versus State of Rajasthan, in this instant, as noticed above, the learned single judge has rightly held that the controversy with regard to the existence of the union was set aside by the division bench at the aforesaid. Therefore, whenever it has been referred, whether it is a recognized union or not, that should not be disputed.
That's all.
And so far the power and jurisdiction of this court, 2000 volume 4, Supreme Court cases 245. Supreme Court cases 245.
Para 38.
Huh.
Para 38.
Yes, that is in Indian versus Bank. Para 8. 64 Supreme Court.
बताइए पैरा नंबर.
Yes, para number.
Madam, if you will, you have to tell me the specific paragraph and place the judgment. So ऐसे खाली judgment बोलने से तो हम पूरा बैठ के.
Yes, para.
On what point you are referring?
I am raised that point, my lord, when the
Regarding the jurisdiction.
Yes.
Or 227 or 226.
Yes.
Which paragraph are you referring?
I shall give the paragraph only just now.
बाद में नहीं चलेगा ना मैडम. ये किताब दीजिए मैडम.
Just
You just refer to the paragraph.
yes. And 1964 Supreme Court also.
ये 86.
Yes, C, madam, section C. That is paragraph. constituency measure in interference with the pure finding of the fact. The appreciation of the evidence is impermissible. High Court does not exercise.
Para number?
Para number.
देखिए बात जो है इसके SCC से इसके लिए दूसरा चलिए हो गया मैडम? Yes, yes, Mr. Das now you start.
Constituency has been given.
In absence of perversity, there is no scope.
Oh, yes.
इसके लिए
And
आपको
so
कोई
far-
judgment का जरूरत ही नहीं है.
Yes, and so far the 1964 Supreme Court, page 477.
मैडम एक प्रोपोजिशन के लिए सुप्रीम कोर्ट का क्या इस हाई कोर्ट का भी एक ही जजमेंट सफिशिएंट है.
ठीक है. तब
इसलिए रिपीट
nothing is
एक ही
repeat.
प्रोपोजिशन के लिए 10 जजमेंट करने के लिए हमको 10 जजमेंट डील करना पड़ता है. इसका कोई फायदा ही नहीं है. For one proposition, you choose one judgment and you just give it.
And another judgment is important. 1988 supplementary Supreme Court cases 768 paragraph 10.
Supplementary SCC,
SCC
page number
768
768, para number.
para 10.
What is it for?
That is the fact finding inquiry cannot be interfered by the Honorable High Court. They should not search out the holes or the holes in the award. That is the case. And one judgment it may be referred by my learned friend, that is 2015 volume 4 Supreme Court cases 482. To cut short the matter, I want to say that my case, fact and circumstantial evidence is different from that. Therefore, that is not.
I don't know. He has not yet replied.
I have given the compilation. I have already given the compilation.
Okay, you just please. Madam, you just sit down now
Yes, sir.
and
He will.
listen to him.
Yes, yes.
Lordship, should I go point by point? Your Lordship?
You can go point.
But if your Lordship wishes to have the order sheet of the learned court,
Yes. So first point would be
first point, your Lordship, the reference is vague. It does not contain any number of workmen and identity of workmen who are involved or who have raised the dispute,
vague, neither number
nor the identity of workmen who have raised the dispute.
nor identity.
Now, if your Lordship sees the list also, which they are saying that it was sent, the list has been sent, though it contains that it is from the ministry, it has been signed by the ALC, who is the conciliating officer. And page 3 of the list, it is a list provided by the workman. It is not on any fact finding. When the dispute was referred, Lordship, can you see page 3 of the list? There are two bunches, Lordship. One is exhibited document.
Yes.
Second bunch contains the list. Can you see, Lordship, page 3 from the top?
1 to 88 employees.
Yes, Lordship.
This is the
Just
list.
the cover letter, if your Lordship sees one page before,
Cover letter.
page 3. It is signed by Sujit Kumar Saw. That I am providing
Yes,
the
Sujit
list.
Kumar.
Yes.
He provided the list
List.
on 17/5/2017.
Without disclosing who are the persons, whether they are workmen, whether they are not workmen. So they started fetching names who have retired and prepared a list because that maintainability dispute was raised by us. So these are not the people who have raised the dispute. And first he gave one.
There is no authorization from their side.
No authorization, nothing is there on record, and not exhibited. Secondly, Lordships, when they want to prove the case, why I say that what is perverse? They will have to show that these are the workmen who had been retired under the voluntary retirement scheme. It is not the part of the pleading that we cannot reply. So now if they want to prove something by way of document beyond pleading, firstly it has to be seen whether it is admissible or not. And secondly,
The written statement filed by them also does not give a list of the
no,
employees.
nothing.
It is just
It
referring to
simply
the
says
circular.
that the employees have retired between not even the date of retirement or
Nothing is
date of
mentioned.
scheme, nothing is mentioned. Lordship has seen
I've seen.
1.5 page. Now, Your Lordships, there is no document to show before the court that these are the people who had retired under voluntary. There has to be a separation order. No separation order on record.
So terms and conditions of separation is also not on record.
Not on record. Now, your lordships, to decide that whether the preliminary objection raised by us is to be decided at the time of preliminary stage or at the final hearing, lordship may kindly see the order dated 24/2/2020. Lordship, it takes almost 3 pages to write down that it will be decided at the time of final hearing. And in the final hearing, in 4 lines, he said that it is decided because they have retired.
This is order dated
24/2/2020.
24/2/2020.
And while deciding it at the time of award, does not even note what is my objection on maintainability. The simple one line that all the persons who are given in the list are the people who have retired under the voluntary retirement scheme, therefore it is maintainable.
What was your nature of objection?
Also, nature of objections were the same which we are raising here. One, it was by an unrecognized, but no list mentioned. The people who are representing are neither the trade union, because if you lordship see section 36 of the Industrial Dispute Act, also workman can be represented by the workman himself or by the trade union. So they are not the trade union, admittedly. A body which is neither registered nor having any legal entity raises a dispute and it has been entertained by them.
What else?
Yes. So, if you lordship, just for your lordship convenience, may I read out section 36?
Yes.
Of representation of parties. 36(1) is with respect to workman. A workman who is a party to a dispute shall be entitled to be represented in any proceeding under this Act by a member of the executive or other office bearer of a registered trade union of which he is a member. 1. Go to section 36.
Yes. Continue.
B. Any member of the executive or other office bearer of a federation of trade unions to which the trade union referred in the clause is affiliated. C. Where the worker is not a member of a trade union, by any member of the executive or office bearer of any trade union connected with or by any other workman employed in the industry in which the worker is employed and authorized in the manner as may be prescribed. So all the 3 things are absent here. There is no adjudication that name people in the list whether they are workmen at all or not.
No,
And
once
we
the
have-
reference is made,
Yes.
then the person is entitled to be represented through these persons.
Yes. So
But the reference in this case was already made.
the reference was made. The reference does not contain name of any person.
That's right. That we are noted.
Yes.
That we are
And
noting
even
it
before
from
the
day
tribunal
one.
also, Lordship, the people who are representing were not
Were not
amongst any of the-
examined.
Yes.
There is no oral evidence.
No oral evidence.
None of the persons have come up to get themselves examined.
Yes. And now, Your Lordship, may
And
kindly
this
see,
list was also not exhibited.
this list was never exhibited, and it is not a corrigendum to the notification by the competent authority of the ministry.
Because the authority, the award holds that it's a part of the reference.
Part of the reference, yes. That is a perversity which is on the face of it. Now, Lordship, much was argued that management did not lead any evidence, did not exhibit. Lordship, may kindly see how, Your Lordship, this case we were debarred from leading evidence. Lordship, may kindly have a note to order dated 4/3/2021. Lordship, I had read the order on the last date whereby all the documents were marked as exhibit.
Yes.
Lordship, may kindly,
4/3/21.
yes.
Yes.
Lordship, I am not reading the entire again because that will be.
That's why not required.
Yes. Lordships, may kindly see till the 4th paragraph, it runs to the 2nd page. All the documents of the workman has been marked as exhibit till exhibit W11. Has the Lordship seen?
Yes.
Now next line is very. The learned lawyer for the management has not made any prayer for marking any of its documents as exhibit. In this view of the fact, the evidence of both sides is closed. The evidence of the workman's documents have been marked exhibit on that date. Date has to be fixed for our evidence. Has the Lordship seen?
Even if there is no oral evidence, no documentary evidence, there could be oral evidence also.
Yes, no, so there has to be a date fixed for evidence. Says that management has not made any prayer for marking. Let's say that was not a stage. court was marking the documents of the workmen on as exhibits on that date.
Is it your grievance in your petition?
I'm just showing from the record, Lordship. So these are now, Your Lordship had put a question to me about circular dated 1995, exhibit W1. Lordship, can you call you?
W1.
Lordship, each word is because every exhibit W2 has been issued on compliance of this.
That's right.
So each word is this is for information of all the concerned that employees who have retired or will be retiring under the under the company's voluntary retirement scheme, means there was already a scheme existing in 1995, will be entitled to the wage revision, pay revision benefits, and as and when the same is finalized. So there was already a scheme there. On that scheme there was a wage revision pending. That also I'll show it from their exhibits only.
That is why I was just asking her. The scheme for VRS is such an important document.
Yes, they have not filed it. Still the court grants them benefit without even looking, presuming everything in the...
And scheme could be revised from time to time.
Yes.
There should be various terms and conditions of the VRS. That is not there on record at all. They have not exhibited it.
Yes, Lordships. And Lordships may kindly come to exhibit W11 at the same...
Yes, W11.
Why I had asked you, Lordship, to just mark the word the voluntary retirement scheme. Lordship may kindly come to the memorandum of settlement starts in the page 1. The pagination is in the bottom of that exhibit. Lordship may kindly come to page 3 of that document.
Yes, I am at page 3.
It starts with short recital of the case, preamble. Lordship may kindly come first page division, thereafter second, everything is mentioned. Lordship may kindly come to the fourth.
Yes,
Fourth All India Wage Settlement was signed on 20/12/95, which was operated from 1/11/1992 to 31/10/1997. So, Exhibit W1 talks of this wage revision which was about to be signed. That letter is of October and in December it was signed. So, it was in pipeline and therefore that letter was issued. It has nothing to do with the subsequent voluntary retirement scheme which was not even contemplated at that point of time. That in future there will be any new voluntary retirement scheme. And
on top of that, that exhibit 5 is there.
Yes. Exhibit 5 is there. I will come to that later on. Lordship, thereafter, Lordship, you kindly come to the 4th page of this document.
Yes, 4th page.
The settlement covers all the regular workmen born on the roll of Hindustan Copper Limited on 1/11/90 subject to the condition enumerated in para 7.1 and 8.1 of the memorandum of settlement. This provision has been interpreted by the Supreme Court while relying on the judgments that regular employee is a separate class from the employees who opt for voluntary retirement. Lordship, thereafter Lordship has already taken note of clause 7.1. That from 1997 it will be a notional fixation, actual monetary benefit from 2004 onwards.
And 8.1.
7.1 and 8.2 Your Lordships. So I am not repeating and not reading it again. My Lordship, one document which they have argued that areas were also released, and that is an admitted fact, my learned friend said. Lordship, that is exhibit W4.
W4. Yes, exhibit W4.
Lordship may kindly see, I am not reading the Lordship may kindly see, I am directed to refer to a letter number such and such dated 9/7 on this subject and convey the approval of the government for payment of residual areas arising out of 1997 pay revision for the period from 1/1/1997 for executives or 1/11/1997 for non-executives to 31/7/2002 to the existing employees and those retired otherwise than on VRS in 2 installments in the current fiscal year subject to availability of surplus funds. This I am giving you permission, we will not give you any aid. You can give, to the employees who have not retired under VRS, but subject to availability of fund. Thereafter, no other document produced that actually that payment was made or not made. Thereafter, Exhibit 5, Your Lordship has already seen question number 19. Now issue will arise, what is the difference? Lordship, that when a questionnaire was framed by the ministry, and it is their document, instead of relying on the scheme, they wanted to rely on this document, wherein specifically a question was framed that will notional pay revision from 1992 and 1997 will be taken for computation of VRS benefits. The government says as per new VRS/VSS scheme, there is no scope for computation of ex gratia on notional salary revision. So it was clarified, everybody knew that no, it will not be included. Still, if you want to apply, you apply.
That's all.
And thereafter, Lordship, they have referred to one of the reports, that is annexure.
Annual report.
Annual
2006-7.
Yes, Annex Exhibit 7. That is at page. Yes. That your Lordship, you can see in the first page itself. It is of 27/3/1980. It is of no relevance at all. And therefore, the scope part they deliberately did not get it exhibited.
Exhibit 7.
Exhibit 7. And Exhibit 6, if your Lordship sees,
This is annual report 2006-7.
yes,
We are referring to clause number 8.
yes. Lordship, mark one more part. The voluntary, Lordship, can you see clause 16.1?
Yes.
The voluntary retirement expenses paid from out of its own fund, voluntary retirement expenditure incurred by the company is charged to the revenue over a period of 60 months. So whatever we had paid, we had to recover it. It took 5 years for us to make good that amount which we had paid. This will be relevant, Your Lordship, when I refer to the judgments, Your Lordship. The Honorable Supreme Court says that considering everything, they give a voluntary retirement so that they know where they stand
There's
after
a proper computation.
proper computation. Therefore,
It is not
after
just
giving
out of the
voluntary-
blue, they do not get it.
they cannot all of a sudden claim the benefits. Now, Lordship, coming to the legal issue. Lordship has the compilation which I
Yes, I have.
in the note, Your Lordship, the first judgment, the relevant paragraphs I have mentioned in the first page, but I have not quoted the relevant paragraphs. Lordship, may I read out from para 11 onwards? It is at page 8. That this is a judgment 2006 volume 3 SCC 708 of HEC voluntary retirement. An offer of voluntary retirement in terms of a scheme when accepted leads to a concluded contract between the employer and the employee. In terms of such scheme, an employee has an option either to accept or not to opt therefore. The scheme is purely voluntary in terms whereof the tenure of services is curtailed, which is permissible in law. Such a scheme is ordinarily floated for the purpose of downsizing the employees. It is beneficial both to the employees as well as the employer. Such a scheme is issued for effective functioning of the industrial undertaking. Although the company is a state within the meaning of Article 12 of the Constitution of India, the terms and conditions of service would be governed by a contract of employment. Thus, unless the terms and conditions of the contract are governed by a statute or statutory rules, provisions of the Contract Act would be applicable both in the formation of the contract and also for determination thereof. by reasons of such scheme only is an invitation of her offer floated. So that invitation is not on record. When pursuant to and in furtherance of such a voluntary retirement scheme, an employee opts thereof, he makes an offer which upon acceptance by the employee gives rise to a contract. Thus, as a matter of relating to voluntary retirement is not governed by any statute, the provisions of the Contract Act 1872 therefore would be applicable to. It is a common knowledge that a scheme of voluntary retirement is preceded by financial planning. Finances are, for such purposes, either in full or in part, might have been provided by the central government. Thus, financial implications arising out of the implementation of a scheme must have been borne in mind by the company, particularly when it is sick and the industrial undertaking and offers of such number of employees for voluntary retirement in view of the matter may be accepted by the company only to the extent the finances are available thereof. Thereafter, Lordship, kindly see para 18. A voluntary retirement scheme speaks for a package Either one either takes it or rejects it. While offering to opt for the same, presumably the employee takes into consideration the future implications also. It is not in dispute that the effect of such voluntary retirement scheme is cessation of dual relationship between the employer and the employee. Once the employee opts to retire voluntarily in terms of the contract, he cannot raise a claim of a higher salary unless by reasons of a statute he becomes entitled thereto. He may also become entitled thereto even if a policy in this behalf is formulated by the company. Therefore, Lordship may kindly come to para 22. The financial considerations are thus a relevant factor both for floating a scheme of voluntary retirement as well as for revision of pay. Those employees who opted for voluntary retirement make a planning for their future. At the time of giving option, they know where they stand. At that point of time, they did not anticipate that they would get the benefit of revision of pay scale. Division of pay. They prepared themselves to contract out of the dual relationship by resorting to a golden handshake. They are bound by their own act. The parties are bound by the terms of contract of voluntary retirement. We have noticed herein above that unless the statute or statutory provisions interdicts the relationship between the parties to act pursuant to and in furtherance of the voluntary retirement is governed by the contract. By the contract, they opt out of such terms and conditions as may be agreed upon. In this case, the terms and conditions of the contract are not governed by the statute or statutory rules. Then your Lordship can come to the last paragraph of the para 28. That is at page 12. Para 28. The expression special scheme used therein must be understood in the context of general scheme of the employment governing the terms and conditions of the service, or which is a part of statutory rules governing the services of the employee. In this sense also, the voluntary retirement scheme is a special scheme. The scheme was initially introduced for 1 year. It might have been extended from time to time. The extension of such scheme indisputably must have been on the basis of exercise resorted by the employer as regards to financial implications thereof, availability of funds, average number of employees opting therefore, and other relevant factors. Only because the scheme remained in force for a total 10 years, same would not mean that it has become a part of general conditions, terms and conditions of contract of employment. Therefore, evidently, the scheme floated in 87 did not work to the satisfaction of the company. It was replaced by 1990 scheme for spending more benefits to the employees. Therefore, 30. It has not been suggested that voluntary retirement in absence of any express statutory rule governing the field would bring the case of superannuation. In V. Christie, a new rule was introduced providing for pension to the employee after retirement on completion of 20 years of service, provided that he requested in writing thereof. The question which failed for consideration therein was if a person was eligible for pension at the time of retirement or if he survives till the date of subsequent amendment in the subsequent pension scheme, whether he would become entitled to the enhanced pension or would become eligible to get more pension as per new formula of computation pension. In the fact situation obtaining therein, it was held that the employees will be divided into two categories: one who was eligible for pension at the time of their retirement and those who were not. Whereas in this in the case of first category, the benefit of amended provisions would be applicable, but in the second it would not. V. Kasturi was thus, in our opinion, is not applicable to the facts of this case. Thereafter, Lordships. Para 33. Although either before the High Court or before us, no submission was made relying on the basis of Office Memorandum dated 5/5/2000, copy of which has been annexed only with the written submissions, we are of the opinion that the same would not advance the case of the appellants for more than a reason. Firstly, the said Office Memorandum dated 5/5/2000 cannot be considered by us as the same was filed for the first time in written submission. No opportunity has been given to the respondents to respond to. Secondly, the same is a general circular where the circular dated 24/5/93 issued by the Union of India deals with the particular problem wherein it has categorically stated that central government shall not undertake the financial responsibility thereof. Same is the case here, Your Lordships. In that event, the said letter refers to the scheme which might have come in force in 2000. It evidently does not refer to 1987 scheme vis-a-vis the revision of pay scale. The appellants are really relying on the basis of such and such foregoing reasons, view the impugned judgment cannot be faulted, appeals were dismissed. So they were found not entitled to benefits of this scheme. Now, Lordship, can we come to the second judgment, 2015, Volume 4 SCC 482. So the relevant paragraph is paragraph 28. May I read it?
Yes.
There is no doubt that the scheme has been framed by the employers to see their expenditure in long term is decreased by making one-time payment of additional amount to the employees opting for retirement under the scheme. Strength of the staff was going to be reduced substantially due to the voluntary retirement of several persons, and reduction in the staff was a result of reduction in the burden of salary and establishment expenditure. With the aforestated intention, which has been clearly revealed in the scheme, the employer had floated the scheme and several employees of the employer had taken due advantage of the scheme by opting under the scheme and by taking not only ex gratia payment of salary but also additional pension which would not have been received otherwise. It is not in dispute that the employees opting for retirement under the scheme were to get the benefit of additional 5 years of service by calculating pension. Here, Lordship, they got 6 years benefit. As a result thereof, the said benefits were substantial, and the said benefit along with the benefit of ex gratia payment tempted number of employees who opted for scheme and retired happily after getting all the retirement benefits. Normally, retrospective rise in salary is given to those who are in service at the relevant time and those who have retired in normal circumstances. The employees who had opted under a scheme had not retired as per the normal conditions of service and had retired under the scheme upon taking some additional benefits. Here is the catch, Lordship. And thereafter, Lordship, may kindly come to para 31 onwards, Lordship. In the instant case, it is crystal clear the employees who had already opted under the scheme were under a specially made scheme, which was framed only with the intention to reduce future expenditure of the employer. If all the benefits were given to the persons who had already opted under the scheme and had retired, the real purpose with which the scheme has been framed would be frustrated. We do not agree with the submissions made on behalf of the employees that action of the employer in not giving pay rise to the employees in pursuant to the notification is discriminatory in nature. This was the argument, Your Lordship, referring to 2008 letter. The employees who retired under the scheme form a separate class of employees who were given many benefits which were not given to the employees retiring in normal course. If they all form a separate class, by no stretch of imagination, it can be said that all those employees who retired under the scheme and those who retired in normal course are similarly situated. Thus, in our opinion, there is no violation of Article 14 of Constitution of India in the instant case. Similarly, there is no violation of principles of equal pay for equal work. True that those who retired under the scheme did the same work which were being done by those who retired in normal course. But one cannot forget the fact that who retired under the scheme got substantially higher retirement benefits In these circumstances, we do not accept this as submission. Then your lordship may kindly come to the 2023 judgment, your lordships. That is starts from page 23. The 11th paragraph would be paragraph 40 and 41. 2023 volume 11 SEC. Lordship will kindly come to paragraph.
See, there cannot be any doubt on this, that a regular employee attaining the age of superannuation and a person opting VRS, they constitute a different class altogether.
Yes.
They cannot be equated by.
There are a series of judgments. I did not refer to 2003 judgment, lordship. That was taken note of in 2006 judgment.
Yes.
And
Not
2023 is the
required.
latest view, para 40 and 41. It has summarized here.
Yes. That I have seen.
Yes.
That should be sufficient.
Yes, and therefore, lordship, this honorable court also, in one case, lordship, I have cited. Lordship may kindly come to para 13 of that judgment, page 49. Lordship, first 4 is necessary, thereafter 33 is to be ground as we take. Para 13, Roman 1. As a lordship. Be that as it may, having gone through the rival submission of the parties, considered to be admittedly the order passed by the labour court is perverse and diverts the rules of following reasons. It is settled that law of voluntary retirement scheme splits a package, one takes it or rejects it. While opting for the scheme, presumably the employer takes into consideration the future implications also. Employees who had opted under the scheme were planning for future. And this was their argument also. There was a stage of uncertainty, minds were getting close. They thought if I don't take the benefit, I will be retrenched. They did not take the risk, they said that I am getting
And the
6 years.
retrenchment compensation will be paid
Paid.
for 6 years.
Yes, which is much less than the actual. Therefore, they thought that financially they have taken a decision. Later on, those who wanted to sell with us, either sink or sell with us, they got the benefits of pay revision. Now they cannot say, give me that benefit.
Those who got retrenched, they also got the benefit
No,
by virtue of this.
there was no. In fact, there was no retrenchment.
Everybody opted for VRS.
No, there were people who got the benefits of pay revision also. Therefore, that wage settlement was signed in 2007. When the company opted out, sailed out of the hardships, they came in a comfortable position. Union also cooperated with us, and they signed it in 2006.
No, I want to know that maybe it is not born out of record. That those persons, there were 2 categories of persons. Somebody might have opted for VRS, somebody might have taken retrenchment compensation.
Nobody got retrenched.
Nobody got retrenched.
Yes.
So because that was more beneficial to them, by all means.
No, many people, they did not opt for voluntary retirement. Otherwise, had everybody opted, there was no question of any wage settlement.
In case of closure,
No, in case of closure, they were those who were left, they were adjusted.
they were reduced.
Yes. This was only a scheme given so that we know how much workforce we have, residual
Absolutely.
workforce. Then we can take care of their interest. Those who wanted to sell with us and take the risk of sinking with us.
That's all.
So yes, so this is on merits, lordship. They had no case. On reference, it was not maintainable. Award is perverse, and lordship has seen how
Reference
perverse.
was not maintainable. How do you say after the reference is made, you have not challenged the reference?
Lordship, the law from 1983 Supreme Court onwards was you have to wait till the final outcome. We raised the issue of
No, see,
maintenance.
when the reference is challenged, reference is challenged even in the late petitions.
No, they are challenged. Refusal is
But
also
can
challenged.
once the reference is made, the reference has to be answered.
Reference has to be answered if if the court finds that it has not been raised by the
Proper union.
or they are not workmen at all. Therefore, they framed the issue of maintainability, kept it for deciding at the time.
And
Finally,
ultimately did not decide.
did not decide. Lordship. That is no decision at all. And there is
Yes,
no decision.
Amicus, do you have to say anything?
Yes. Whenever you want to say.
And just a moment. Yes, do you have to say anything?
Your Lordship, I will just place on record one judgment that exact same issue of HCL BRS separated revised 97 wage revision that was being dealt with at the Honorable Rajasthan High Court and has been answered in favor of the workman. However, there is an appeal pending. But all the arguments that has been done today, that's summarized in that judgment.
Where is that judgment? Rajasthan. They must have gone for computation. This is pending in SLP.
No, before the division bench.
Any relevant paragraph you want to cite?
Paragraph 9, 12, 16, 20 and 20.
9, 12, 16, 20 and that's all? Yes, madam, what do you have to say in response?
Yes, madam. I want to say that so far the maintainability of the differential, that point was not raised and it has not been decided. That is my submission, that is not correct. Page 35, the reference except is sufficient to show whether the ex-employee of the Messrs HCL who are separated under the other scheme due to closure of the mines, that is are entitled to the arrears wages arising after subsequent paid wages and paid pension. Therefore, only because of that has been raised by a workman on behalf of the all workman is not a registered in manner, that is not maintainable in view of the judgment I have submitted, my lord. Page 52 I have given that, whether that is recognized Indian or the workman that is not to be looked out, that is division bench judgment, only the terms of the reference the dispute has been referred and it is the duty, statutory duty to decide the point, and it has been decided on the basis of the evidence and record. Second point is that all the settlement has been given to VRS. VRS is a separate class, that there is no dispute for that. But VRS, what they are forced to give the VRS, that is the closure. If not, I have submitted, then dismissal order. And it has been narrated in the
Dismissal with some benefit of 6 years salary.
Yes. That is the package about the VRS. It is not the case when the package has been given, they are not entitled for the revision because the W1, exhibit W1 and W2 and W3 is enough to do that. That is apart from the benefit and includes that such and such. And the illustration correctly says that the VRS scheme is important, but whatever has been exhibited W7, that is the terms and what benefit they will get, that has been mentioned. 6 years service and whatever maybe the package has been mentioned there. W7.
W7 is for retrenchment.
Not VRS also.
For retrenchment.
No. With great respect, that is VRS. And so far, yes. And so far that point is concerned that no.
You see W7.
W7 is of 1980.
Maybe 1980. That is office memorandum of 19 or 2020. Exhibit 5. Sorry. Exhibit 5. Sorry. Exhibit 5. That is dated 8 December 2000. And all the revisional.
So exhibit 5. So
yes.
that is why I was looking for it. How does it reconcile clarification 3 with clarification 19?
19 and 3 also important. If you
They are contradictory.
Yes, if contradictory, what will be the relied upon? It has been said.
So there is no discussion of this
Clause
3 or 19. There is no discussion.
Will be recalculated on the basis of the revised pay scale. I am not claiming the pension on the basis of the revised pay scale, my lord. The decision which has been cited by Learned Fate, that is 2015 volume 4, Supreme Court cases 482, it has been discussed, and hence such employee would not be entitled to additional pension due to retrospective increase. But they are entitled for the ex gratia. They were entitled only to revision of ex gratia amount upon retrospective increase of salary, not revision of the pay. We are one time. That the decision is that, my lord, no revision of pension will be made, which the regular employee or retired on superannuation are getting. But we are, if no pension is, then the matter ended. Then in this case, my lord, there is a provision for pension and it has been held in paragraph 13, 14, 29 and
You are
30.
getting pension also?
No, they said pension, no pension. Therefore, my lord, kindly consider that employees who are, that is the placitum 13, 14, 29 and 31, employees who are opted under BRS 2004 are entitled only to division of ex gratia amount upon retrospective increase of the salary. We are wanting that, and not division of pay, not pension. In that case, there was a pensionary benefit, that's why it has been given. And the point which has been raised by learned friend that no opportunity was given to adduce the evidence, that is not tenable in the eye of law. Only they have filed the rejoinder, that is Annex 3, that is Annex 3, page 31. They have raised that point, the list of the workers is not mentioned, and they are not the retrenched, therefore they are not entitled for the benefit. And no application was filed, that time may be granted to adduce the evidence, therefore they can't take that plea. And in this case, my lord, there is no doubt and there is no dispute. There are a class of the people, but in my case there is a separate difference on the case of the 2015 four Supreme Court cases, that they opted for PRS. We are forced to live on PRS, and it is stated the ex gratia, all are entitled for that. Then there is no meaning of W1, exhibit W1, W2, W3, and W11. My submission is that. And that is the fact, they are forced to retire, and therefore they are entitled on it. And the so far the settlement is concerned, when there is a decision of the Supreme Court cases 2017, 2007.
Madam, you have cited your judgments.
Yes,
In rejoinder, you are citing a new judgment.
No new judgment, that has been written. 2017.
Written means where it is written.
Yes, that is the importance of the settlement. 2007 column 8 Supreme Court cases.
It is binding.
Yes, therefore there is a settlement, therefore they are binding.
If there is a settlement, there
Yes.
it is binding. There
Yes.
is no doubt on that.
Yes, that is. And the office order.
Whatever points you have argued, you have raised in your petition, in your written submissions. Because I will not record your submissions right away. You have,
one thing
you have written everything there.
So whatever point I have argued, I have raised it in the written submission, but documents which I have showed the point was, those are not mentioned in detail. If your Lordship permits, I can give
Just
4
one
pages.
page you give,
Yes.
so that it doesn't slip out of my
Yes.
memory. I am not dictating
Yes.
your submissions right away.
By tomorrow, I will.
Normally, yes, by tomorrow you do it, whatever.
Yes.
They have already submitted the written, revised thing.
That one I did not, but I will.
You just do that and give it to us by tomorrow, right?
Yes.
Okay, if you want to also say something, you can say. Arguments can be good. Say it. अपने parents से भी listen.
Item 19, WPC 7135 of 2023.
The scheme is not on record. You please put it in your submissions also. The scheme, BRS scheme is not exhibited.
Yes.
You should put it in your submissions also. Yes. ये इसमें कुछ था written submissions नहीं होंगे. Yes, please.
Leadership at the very outset, if you may just go through the derecognition order that has been passed on 26/4/2023. Annexure 13 leadership from page number 66.
Yes, 66.
The relevant portion leadership starts at page number 67.
Yes.
May I please paragraph 7?
Yes.
Leadership para 7.1.
Let me just make it very clear. You
Leadership.
can just start in your own manner,
Leadership.
right? Do not do not continue from where you left on the last occasion. We are hearing it
Leadership.
finally. So
Yes.
you should start give entire background of the case and then you can just come, or you can just start from
As
where
a
you
leadership.
got. No problem.
Leadership.
Yes.
So leadership, the background of the case. So what had happened is that the petitioner leadership is a service association functioning within the Department of Post. Leadership, the service associations, they are regulated by the Central Civil Services Recognition of Service Association Rules 1993. There under leadership, Rule 5 lays down certain criteria for recognition of service associations. Rule 6 and Rule 7 leadership lays down certain conditions subject to which service recognitions are allowed to function as recognized service association. And Rule 8 states that for a violation of any of the rules, the recognition of any service association may be withdrawn. Law leadership Annexure 2. Annexure 2, page number 49, is the order office memorandum by which the petitioner had gained recognition. It is dated 19/7/2019. If leadership, I may please paragraph 2 of the said
Page number.
office memorandum, page 49, leadership, annexure 2.
Yes.
Leadership may see at serial number 1, category Group C postal, excluding postmen and MTS, All India Postal Employees Union Group C. This is the petitioner association leadership which had duly gained recognition after satisfying the criteria as had been laid down. There in leadership at paragraph 2, it is clearly stated, the above associations have obtained requisite percentage of membership in their respective category and the effective date of recognition of service association will be valid for 5 years with effect from such and such date. Now leadership, this particular recognition came into effect in 2019 and was valid for a period of 5 years.
From 22/9/2015.
Leadership thereafter, what has happened, the department has kept on giving fresh office memorandums, while which the recognition has been kept on extending for a period of 1 year. Admittedly, leadership, fresh re-verification is pending as on this date, and this particular recognition period for the 5 years has already lapsed. Thereafter, leadership, what has happened, that on in July 2022, which is Annexure 3 leadership, if leadership may come to page number
No,
50.
why do you want to refer to this?
Leadership, this reference was made so that I can buttress the point that the derecognition cannot be beyond the period of recognition itself. In the
22/9/2015
leadership,
it was for a period of 5
5
years.
years leadership.
Okay. It expired on
It expired in
21/8/2020.
leadership. The leadership, the period as on this date, the Department of Post, via several office memorandums, has kept on extending the period of recognition for 1 year.
So there was an extension
Leadership,
throughout.
leadership.
Okay, for 1 year.
1 year, 1 year.
But those
constant-
extensions are not there, but it is not.
Yes.
in dispute.
And as of this date, leadership, in August, they have initiated the process for re-verification, in which they have again not included us, saying that we are derecognized.
So each year there is a separate
Leadership.
extension.
After-
The question of extension will come only if there is an existing
Yes, leadership.
recognition,
Leadership.
right?
Leadership.
Since you are not recognized as on date,
Leadership.
therefore there is no question of any extension.
Leadership. But my point, leadership, is that this extension is for the recognition that was granted in this particular verification. Now, leadership, after a period of 5 years, there has to be a fresh system for recognizing service associations, for which verification is carried out again. So these extensions are with respect to the recognition that was granted in the year 2019. When the 5-year period ended, leadership, there is again a process for re-verification of all the service associations. Whether-
Re-verification, is it as good as a fresh application?
Yes, leadership.
So how, under what circumstances they were issuing you letter for extension?
Leadership, that is for Department of Post leadership, because admittedly, even in
Once
2009,
there is a recognition,
leadership,
extension is one thing,
leadership,
right? Fresh recognition is another thing.
Leadership.
It's not one and the same.
leadership. They are totally different leadership.
Yes.
So, as far as leadership, the extension is concerned, I admit, if being derecognized leadership, the extension period would not be for my benefit. But when a re-verification process is to counted leadership, that is a completely different process as for the verification that was concluded earlier. And I am bound to be included in the re-verification process leadership, because a service association, whether it is recognized or
Then you have to apply afresh.
leadership, We are ready to apply leadership, but what Department of Post has done is that they have not even invited us for application. They have
You have to make an application, whether they
Leadership.
will accept it, reject it, do whatever.
leadership.
But the point is that you have not made a fresh application.
Leadership, when the re-verification process started in August 2024, Department of Post sent out a letter to all the service associations, whether recognized or unrecognized, asking for the constitutions and the bylaws so that they can initiate the re-verification process. Admittedly, leadership, no such letter has been given to us. We even
It is not a case of re-verification process. In your case, it would be a case of fresh verification.
leadership.
A new application altogether.
Leadership. And we are ready to, leadership, we have even written to the Department of Post that in the re-verification process, our candidature
They
should
have
be
a right to
confirmed.
reject your application.
Leadership, that has to go by the CCS rules, leadership, in which the criteria has been laid down. If we fulfill that criteria,
suppose a particular association is rightly held to be not working properly.
leadership,
So upon fresh application,
leadership.
their previous conduct will not be taken into
Leadership,
consideration.
that conduct was for the period for which it was recognized. It was only for a period of 5 years. Even leadership, in my supplementary affidavit, it has been clearly stated the earlier.
We are not on that. The scope of this writ petition is regarding just your
Leadership.
recognition or whatever.
Leadership.
So whatever be your right arising out of fresh verification or
Leadership.
re-verification or whatever, that is a distinct right which you can exercise as per laws. For that we are not here.
My contention, leadership, I raised this point was that my derecognition, leadership, cannot be in perpetuity. And as such, it cannot be beyond
Have they passed an order that you can never apply for fresh?
leadership. If
They have not passed such an order.
leadership, if we may come to the page number 50, just a second. Annexure 13, leadership, which is the derecognition order. Page number 69.
Yes, page number 16.
69, leadership, para 9. Therefore, as decided by the competent authority, the recognition to All India Postal Employees Union Group C, as well as National Federation of Postal Employees, are withdrawn with immediate effect till further orders. Now, leadership, till further orders, this clearly simplifies that they have derecognized us in perpetuity. This is what I am contending, leadership, that this cannot be there. That I cannot be derecognized in perpetuity, leadership. This is my first limb of my argument, leadership.
Is this the grievance you have raised in your writ petition?
I have raised in my petition, leadership.
Where is this? Which paragraph?
Yes, leadership. Paragraph 67, leadership.
67.
Leadership.
Yes.
If I may place paragraph 67.
Yes.
That it is further stated and submitted that the said action of respondent Department of Post also suffers from procedural impropriety as well as patent illegality. As such, order revoking the recognition of the petitioner association has been passed without due appreciation of evidences presented by the petitioner, and order has been passed by the respondent department without presenting any evidence to substantiate its allegations. Moreover, the said cancellation of the recognition of the petitioner association appears to have been done in perpetuity.
What is their response to this?
Leadership. They have only stated that the said governments are disputed and denied, leadership.
Denied. So it is
Their
not in
counter
perpetuity
affidavit.
according to them. And which judgment are you relying upon for this?
Leadership, that was with reference to blacklisting, leadership, in which the Honorable Supreme Court has clearly stated that blacklisting as a punitive measure cannot be done in perpetuity and has to be only for a fixed period of time.
So you do not have any such judgment so far as trade union is concerned,
No.
but you are referring to a
Leadership,
blacklisting judgment.
leadership, because for trade
Taking
unions,
a cue
leadership,
from what I have observed.
leadership for trade unions, every statute which is there for trade unions as well as the code of discipline, leadership, each of them clearly states down that recognition can be for a maximum period of 1 year. And in which conditions the derecognition will be for 1 year. In the code of discipline, leadership, if I In the Maharashtra Act for Recognition of Trade Unions leadership, normally the recognition is only for a period of 2 months, and in certain cases it is for 1 year. So leadership, the question of judgments for derecognition period.
Is there
for-
any such concept of permanent banning in organization?
Not that I am aware of.
As per the rules and regulations also there is no such concept.
No.
Under which provision of, so just give me the citation so that I remember that blacklisting judgment that it cannot be in perpetuity.
Leadership, it is 2014, 14 SCC 731. Paragraph 12 and 25.
Para 12 and
25.
which is the rule which they have invoked.
Leadership, Rule 8.
The rules have been placed on record.
Leadership, Annexure 1.
Annexure 1. Let us have a look at rule 8.
Leadership. Rule 8 is at page number 48. Leadership.
48. Okay.
Withdrawal of recognition, if in the opinion of the government, a service association recognized under these rules has failed to comply with any of the conditions set out in Rule 5 or Rule 6 or Rule 7, the government may, after giving an opportunity to the service association to present its case, withdraw the recognition accorded to such association.
There is no bar that you cannot apply afresh.
No, there is no bar.
Okay. Let us see that provision which gives a recognition for a particular period.
Leadership. That is at page number 46, leadership.
Okay.
Rule 5, conditions for recognition of service association. A service association which fulfills the following conditions may be recognized by the government, namely, A. An application for recognition of service association has been made to the government containing memorandum of association, constitution, bylaws of the association, name of office bearers, total membership, and any other information as may be required by the government. B. The service association has been formed primarily with the object of promoting the common service interests of its members. C. Membership of the service association has been restricted to a distinct category of government servants having common interests, all such government servants being eligible for membership of the service association. D1, leadership is primarily D1 and D2 which govern recognition. D1, the association represents minimum 35% of total number of a category of employees, provided that where there is only one association which commands more than 35% membership, another association with second highest membership, although less than 35%, may be recognized if it commands at least 15% membership. D2, the membership of the government servant shall be automatically discontinued on his ceasing to belong to such category. E. Government employees who are in service shall be members or office bearers of the service association. F. The service association shall not be formed to represent the interests or on the basis of any caste, tribe, or religious denomination or of any group
No,
within.
we are not concerned with that. I
Yes,
just want to know what is the fixed period by virtue of which the recognition is to be granted for a fixed period.
Fixed period for that matter, leadership, if we may have my supplementary affidavit.
Yes. From where do they get the period of 5 years? Is it there in the rules or any norms?
I'll just indicate that, leadership. Page number 18 of my supplementary affidavit may be seen, leadership. So on the last date, leadership had placed the query to me whether what were the trade union facilities that are provided, leadership. So this has a brief of all the trade union facilities.
Of your last supplementary affidavit?
Yes, leadership, wherein I have annexed the entire constitution of the service association.
Yes, where is it? Page number?
Page number 18, leadership.
18.
At para 2, leadership. Under the heading of recognition, if I may please.
Yes.
The verification process for the purpose of recognition is conducted through a check-off system which is carried out in the department once every 2 years in terms of DOPT OM number so-and-so dated 31st January 1994. Consequently, recognition granted to all eligible associations is also valid for 2 years, after which re-verification process determines their future status. All service associations recognized or otherwise have to apply fresh for participation after every 2 years for the purpose of seeking recognition. Thereafter, leadership, in the note It is
Yes.
clearly stated, as per instructions issued by DOPT OM number so and so dated 11 February 2002, the periodicity of re-verification process for the purpose of recognition has been increased from 2 to 5 years.
So every recognition is a fresh recognition.
Yes, Ladyship.
So you are granted recognition subject to satisfaction of your conduct as per the rules.
Ladyship.
And if you do not conduct as per the rules, so
Leadership.
your recognition stands cancelled only for the period you have been granted.
Ladyship.
So now the period for which the recognition was granted is over.
Ladyship.
So you can go for a fresh
Leadership.
verification provided it is clarified by this.
Leadership.
There is no permanent bar as such
That
under
is
the
what I
provisions
said.
of the Act and
Yes,
the rules. The reason being that you are representing the entire flock
Leadership.
and their interest is to be
Leadership.
taken care of.
Leadership.
So you should be satisfied with that.
Leadership, so what has happened in actuality, Leadership? So, in
No.
essence, Leadership, we have already served our sentence. Since July 2023, the Petitioner Association has been derecognized and all the trade union facilities have been withdrawn as well, Leadership. Today, as on date, Leadership, we are in December 2024. So, admittedly, Leadership, the period of recognition,
Extension period has expired. There is no fresh extension.
fresh
So
extension
as
is
on
there.
date, you have already suffered the derecognition for the period you were recognized.
Leadership, and we are suffering beyond that as well, Leadership, because the
Because you have not applied a fresh.
Leadership, the application is not being considered by the department.
You have
Although
not
that is a
applied a
completely
fresh.
Leadership,
You
if they
were-
allow us
you
to
were
apply,
just-
we will willingly apply for fresh recognition, Leadership. But what has happened as on date, they have again extended the earlier recognition period that was there till the year 2025
For others.
for others, Leadership. And
Naturally, for others
Leadership.
there is no problem.
So, Leadership, for the re-verification process that is happening again, they are not considering our candidature.
No, that is not there on the record.
Leadership.
That is not there on the record.
So, Leadership, my
Let me just
argument
ask them. Let me just ask them on this.
Leadership.
Because the period for which you were recognized
Leadership.
expired.
Leadership.
So you have suffered for the entire period you were recognized.
Yes.
Right? So as of now, your concern is whether your fresh application can be considered as per the new norms,
Leadership.
or whatever with the applicable norms.
Leadership.
Because there is no bar that once you are derecognized, then in perpetuity recognition will be over.
Yes, Leadership. That was my submission, Leadership. That my
So
The
that
recognition
should
cannot be
address
in
your
perpetuity.
concern.
Leadership.
Yes, what do you
But-
say? Is it something in perpetuity?
No, no, so far as that part is concerned, you nothing can consider. So far as the period on which the recognition is going on. For that period, till further order means during that period, that can be withdrawn.
That's
The
right.
withdrawal, so far as
That's
the
right.
order is concerned.
Certainly.
Therefore, it cannot be said to be in perpetuity.
That's right.
It will
We
survive
will
only till
clarify
the longevity expires so far as
That's
the
right.
recognition with
That's
respect
right.
to the other unions are concerned. That can be interpreted to that extent.
Yes.
For all time to come, according to me also, not so
Yes,
far as that
it
part
is
is concerned.
absurd.
That cannot be given.
Any trade union
Yes,
may
no, that
commit
I,
small
therefore,
mistake.
therefore, so far as that part is concerned, not that, so far as that issue is
If
concerned.
that
The
is-
next point my learned friend has observed, I request just day after tomorrow let the matter come up. In the meantime, I will take instruction with respect to the subsequent extension and the fresh application
You
which they
see,
can
you
accept.
don't expect anything from them.
No,
You see, we have to interpret the provisions. You
Yes.
show me from the provision that if person, भाई,
No,
आप
in
एक
fact,
बात बताइए.
I got your
Just tell
lordship
us
point,
one thing.
it was not there, now it is being argued.
आप IPC में कोई crime कर दीजिए.
No, I got your lordship view, therefore I am not saying so far as
So I
that.
was also surprised. Permanently आप किसी को ban कर देंगे ऐसा कैसे हो सकता?
नहीं, हम तो बोल रहे हैं, हम तो खुद बोल रहे हैं कि उसने नहीं होना चाहिए, लेकिन वो जो सब्सिक्वेंट फ्रेश एप्लीकेशन का जो कंसेप्ट बोल रहे हैं ना, इसके लिए कल या परसों रख दिया जाए, हम उसको रिप्लाई दें।
कल दे.
नहीं, परसों हम
नहीं, परसों।
एक्चुअली दिल्ली से हमको इन्फॉर्मेशन लेना होगा, हम परसों रखने के लिए बोल रहे हैं, कल हम बात करके परसों रखने के लिए।
Leadership, I would
एक
be
दिन में कोई
available.
फर्क नहीं पड़ेगा
देखिए
मैडम।
हो गया ना, he will not be
Yeah,
available.
available day after
नहीं
tomorrow,
आप नहीं, कल के beyond नहीं हो सकता. देखिए
ठीक है, कल
it is
रखिए,
a
कल-
very
कल-
very short matter.
कल 2:15 में रखिए,
इनका सारा कुछ unnecessary.
कल
देखिए
2:15 में रखिए।
आप ही बताइए, मतलब वो छोड़ दीजिए. मतलब एडवोकेट को एडवोकेट एसोसिएशन की कहानी समझ आती है. Advocate association is also governed by some law. ठीक है, सम रिकॉग्निशंस कुछ तो होता ही होगा, जो भी एसोसिएशन होगा, चाहे कहीं से भी वो लोग अपना रिकॉग्निशन होगा। ऐसे थोड़ी होता है कि आप एकदम परमानेंटली उसको कर दीजिए, ऐसा नहीं हो सकता। तो आप कल आ जाइए, ये तो बहुत छोटा सा मैटर है, अननेसेसरी।
215 में कल रखिए।
215, ठीक है, ठीक है। Heard the learned counsel appearing on behalf of the parties. During the course of argument, the learned counsel for the petitioner has submitted that the recognition was initially granted for a period of 5 years and it was extended from time to time. And the derecognition order, which is under challenge in the present proceedings, has completed the period for which the recognition was granted. The petitioner has already suffered the derecognition for the remaining period of recognition. The concern of the petitioner is that the fresh application should be considered because there is no bar under the Act and the rules that the association cannot apply for fresh recognition, and under such circumstances, this observation would suffice to meet the justice to the petitioner. And
Leadership, I have other arguments as well, Leadership.
What
Let me just
other
seek to challenge the order.
दोनों चीज कैसे चलेगा? बताइए।
Because the said order, Leadership, which was passed by which recognition has been withdrawn, Leadership, it was based on a complaint. And throughout the entirety of proceedings, Leadership, neither have we received a copy of the complaint nor any evidences in that effect have been presented to us, Leadership.
So you are on the merits next, merit पे जाएंगे। ये हो गया आपका first leg.
Leadership.
Next.
Yes. So the first leg of my submission, Leadership.
Yes.
Leadership, if we may come to the first letter by which allegation had been levelled against us, that is at annexure 3, page number 50.
You just give a background.
Yes.
to this.
Leadership, therein under
Which all are the transactions which are under cloud?
Leadership, if I may indicate, Leadership, the subject of the said letter, it also states various allegations levelled by Secretary Federation
You
BPE.
forget about it. There was a
Leadership.
show cause issued to
Yes,
you.
Leadership.
You come
We'll
to
come
the
to the
show
show
cause.
cause, Leadership.
You don't need to bother about it. There are certain, you have been responding to their allegations
Yes, Leadership.
on the basis of materials. So what is the relevance of the complaint? Whatever is there which has been crystallized in the show cause, that should be sufficient.
Leadership.
So you should not worry about the complaint.
Leadership.
Where is that?
Show cause, Leadership.
Page
is at
45. Sorry. No,
Annexure 9, Leadership, page number 58.
Annexure 9.
Leadership.
Okay. Page 58.
Leadership.
Yes.
If I may place the show cause, Leadership. Whereas you were instructed, write this office letter of even number dated so and so to submit your explanation on the allegations of funding political party and its trade union wing from the union account as well as funding of farmers agitation from the accounts of All India Postal Employees Union Group C. And whereas in response submitted by letter dated so and so on the above allegations, you have admitted funding the farmers movement through Confederation of Central Government Employees. And whereas write this office letter of even number dated so and so, you were directed to explain as to whether various amounts were paid to CPIM, C2 and Farmer Solidarity Funds through online transfer and check payments from AIPEU Group C account. The response submitted by you white letter dated so and so was not found satisfactory, and you were again instructed write this office letter dated 13/12/2022 to submit necessary clarifications. And whereas instead of explaining your position supported by due evidence, you reiterated your earlier submissions, and whereas it is observed that your federation and association donated some amount to Confederation of Central Government Employee and Workers to provide help to farmers movement, as well as rupees 4395 to CPIM, rupees 50,000 to C2. And whereas Rule 5B of the CCS ISA Rules 1993 provides that the service association has been formed primarily with the objective of promoting the common service interest of its members, Further, Rule 5H of the CCS RSA rules 1993 stipulates that the funds of the service association consist exclusively of subscriptions from members and grants, if any, made by the government and are applied only for the furtherance of the objects of the service associations. Rule 6C of the CCS RSA rules 1993 states that the service association shall not maintain any political fund or lend itself to the propagation of the views of any political party or a member of such party. And whereas it is observed that your aforesaid mentioned acts are in contravention of Rule 5B, 5H and Rule 6C of CCS RSA rules, and whereas Rule 8 of the CCS RSA rules 1993 provides that if in the opinion of government, a service association recognized under these rules has failed to comply with any of the conditions set out in Rule 5 or Rule 6 or Rule 7, the government may, after giving an opportunity to the service association to present its case, withdraw the recognition accorded to such association. Therefore, you are instructed to show cause within 7 days of receipt of this notice as to why the recognition of your association as well as federation concern should not be withdrawn as per provisions contained in Rule 8 of the CCS RSA Rules 1993. The leadership, what happened, leadership, that all these allegations have stemmed from a complaint that was made by a different association, being Bharatiya Postal Employees Federation, as has been clearly seen in the earlier letters as well. All were duly replied to, leadership. We have even replied to the show cause, after which the impugned order has been passed. On this note, leadership, I think to refer to a judgment of the Honorable Supreme Court.
You complete the facts and then you come to the
Leadership.
You responded.
Yes, leadership.
So there was two response which were required. One is in connection with rupees 4395.
Leadership.
And other was in connection with rupees 50,000.
Leadership.
These are the two transactions.
There were 3 transactions in question, leadership.
Where is the third one?
One is rupees 4395, leadership. The other is 50,000, and the other one is they have just stated that your federation donated some amount to Confederation of Central Government Employees.
Some amount. So
Yes,
some
leadership.
amount was how much?
From AIPU Group C leadership, it was 30,000.
So where do I get this 30,000? And it must be mentioned in earlier notices.
Yes, leader. So,
Where is
leadership,
it?
the notices as well as the show cause are against 2 entities. The the NFP as well as AIPU Group C leadership.
Yes.
This petition, leadership, we are only constrained to AIPU Group C.
But there is a common show cause to both of you.
Yes, leadership. But NFP leadership being the federating body leadership, we don't have the locus to fight for on its behalf.
You gave a common reply also.
Leadership, because the Secretary General and General Secretary of
What happened to the derecognition of the other group?
leadership, it is pending.
Where?
It is sub judice before the Honorable Delhi High Court.
So arising out of the same show cause notice and same show cause reply and the same impugned order, you have 2 different proceedings. One before the High Court and other before the Delhi High Court.
Leadership,
Very
because
good.
leadership, which was by transfer petition had been filed before the Honorable Supreme Court. Leadership, so what happens, leadership, is that every association has
You see, come to page number 53 and extra 5.
leadership.
There are 4 transactions which are under cloud.
Yes, leadership.
4935, 50,000,
Leadership.
30,000 and 2,50,000.
Yes, leadership.
So all the 4 transactions are to be scrutinized.
Leadership on which the Department of Post has admitted the last transaction with 2,50,000 was not done from the account of AIPU Group C leadership.
Whether the amount of rupees 2 lakh has been paid through check from the account of, so there is a chain transaction. You paid them and they paid them.
Leadership, we have categorically denied in the next page, in page number 54. No amount has been paid from AIPU Group C leadership. And this does not even form any allegation in the show cause leadership. It has.
So then there is a payment of this farmers movement, rupees 1,50,000 and 1 lakh. This was not paid?
No, leadership, not by AIPU Group C. And thereafter, leadership, even.
It was paid by whom?
Leadership, it was not paid. The response may be seen on the next page.
Yes.
At point D, no
Yes.
amount of rupees 2,50,000 has been paid through check from account of AIPU Group C to the account of Farmer Solidarity Fund. And thereafter, leadership, we have even attached the copy of account statements for
The
the
sum of
relevant
rupees 1 lakh was given to
given by NFP to
Yes.
Confederation of Central Government Employees and Workers, leadership.
Then what is ultimately what happened to this?
Leadership.
What is
All
your
this has
response?
culminated in the final show cause leadership which I just placed.
Yes. What is your response to this?
Leadership. That is at annexure 12, page number 62 onwards, leadership.
Annexure 1262.
Leadership.
You have explained all the transactions.
Yes, leadership.
Right?
Leadership.
Even 50,000 transaction has been explained.
Leadership.
You say so far as this 4,000 rupees is concerned, you
Leadership.
disown it.
Leadership, it was inadvertently done
How can
by
it be inadvertently done?
leadership at that time, if I may
Who
just.
can operate your bank account?
Leadership.
Who can operate your bank account?
Leadership, the employees of the association who
No,
work.
no.
Leadership, the person
Who operates your bank account?
Leadership, the concerned account officers are there in the service association at its Delhi headquarters, who are given charge of the bank account to maintain the day-to-day workings of the association leadership. That person leadership, the person concerned who had done the transaction, whether
See,
inadvertently
it's huge money lying in the bank account.
leadership,
Somebody is operating it through whatever mode,
leadership,
right? He must be having all the passwords,
Leadership.
all the access. So he is operating the account and debiting your account,
Leadership.
and subsequently you disown it. How is it
leadership. We have
possible?
show cause that person.
Maybe.
And
Maybe. How do you disown it?
leadership, the transaction was done
No,
by that
very
person.
well. The
Who-
once you are caught, you will disown a transaction
Leadership,
that he
these-
was not authorized.
leadership, he had inadvertently done the
What
transaction as
inadvertently?
an
It means that he was operating the account.
leadership. He had access to the bank account of the petitioner association,
Yes.
being the office assistant of the association leadership. Like leadership at that time, there was corona pandemic going on, and the bookstore was not accepting leadership offline payments, which is why he did
When was he issued the show cause?
leadership.
What is the date? Show it from your show cause reply.
Leadership, the only reply of the concerned person is annexed. If we may come to annexure 19 at page number 82,
You see, the initial show cause was given to you on first show cause is dated. Fourteen seven
2022 leadership.
22.
Leadership.
Okay. The transaction is dated 5/1/21.
Leadership.
When did you show cause it?
Leadership, the person replied to a show cause on 7/1/21 leadership, annexure 19.
Immediately thereafter.
Leadership.
5
I have the show cause with me, leadership. It is not annexed in the records. It may be seen, leadership, with reference to your letter number so and so dated itna. It is to state that I have purchased some books from bookstall of
Page number?
leadership 82.
Sorry, page number 80.
82 leadership.
Yes, 82.
Leadership.
Very well. He responds to your show cause in 2021
Leadership.
and he deposits the amount in 2022.
Leadership, the said bill leadership, which is at page number 83. So leadership, the apparently from the instructions I have received is that the bill, they have taken this bill later on because at that time they did not have the bill. When they said in 2021, leadership, the amount was paid at that time itself for rupees 4,935, and thereafter they have again taken a fresh bill from the
You
said
pay
post office.
online, right?
Leadership.
You have a subsequent bill which is
Leadership.
issued after the issuance of show causes to you, isn't it?
The person was
And when did he deposit the amount?
leadership. The amount was deducted from his salary.
When?
In that year itself, leadership.
We do not know. It was for you to explain whether it was an afterthought or
It was not an afterthought.
How do we know you on the face of this bill? You see 2010-22.
Leadership, the bill was collected later on, leadership, as at that time,
ऐसा bill होता है क्या? Huh? Later on, what is this later on?
leadership, admittedly at that time when the said transaction had occurred, leadership, it was the time of coronavirus pandemic, so they were trying to avoid
So you can have a bill later on
leadership
in
when
coronavirus.
when the issue erupted, leadership,
When the issue erupted, you obtained a bill. This is what we can gather out of it.
Not an afterthought, leadership, as is evident from the show cause itself, leadership. The office assistant was show caused and he duly replied to the same as well.
This bill speaks volumes.
Leadership, I bow down that the date is contentious, leadership, but at the time when the transaction was made, leadership, it has to be kept into account that as few offline transactions were being made possible was that was the standard operating procedure at that point of time, leadership. That minimal offline and hand-to-hand transactions were being made because of the pandemic, leadership.
Because of pandemic, minimal online transactions.
Offline transactions, leadership.
Offline transactions.
Which had resulted in the incumbent Naveen Kumar doing the online transaction, leadership.
We have seen that. Let us see the explanation to rupees 50,000.
Leadership, 50,000 was never paid to C2, leadership. It was given to WFTU, which is the World Federation of Trade Unions.
Under what, for what payment?
Affiliate fee, leadership. They are affiliated to several other organizations.
Do you pay it every year?
Yes, leadership.
And where do you say this? Because this kind of affiliation fee is not finding place in your rules and regulations.
Leadership. Leadership, each and every organization, each and every service association which is recognized or unrecognized, leadership is affiliated to several other federations and associations.
You just read your explanation.
Yes, leadership. It is at page number 63, leadership.
Page 63, para 4.
Leadership. It has been alleged that rupees 50,000 only has been donated to CITU. We found that this allegation is concocted, absolutely baseless and false. This reveals the true intention behind the complaint. NFPE and AIPEU Group C are not even affiliated to CITU since the beginning in 1954 and then NFPE since 1985 and has maintained its distance from all trade union wings of political parties. There is no question of making any donation to CITU, therefore the allegation of funding trade union wing of a political party as violation of the CCS RSA rules 1993 is denied.
Was there any transaction of rupees 50,000 or there was no transaction?
Leadership, 50,000 rupees in total had been given to World Federation of Trade Unions, WFTU as affiliate fee.
It is not mentioned here.
Leadership, because they had stated that whether we have given rupees 50,000 to CITU, which we have categorically denied here in leadership.
They must be referring to a particular transaction. Which transaction? And you were on the last day you were saying that there was a post confirmation also.
That was for leadership, the donation made to farmers movement leadership.
How much amount?
Leadership, that was also 30,000 leadership. That was from AIPU Group C account.
Yes. So you had a now so far as the 50,000 is concerned, this is your explanation. What is your explanation with rupees 30,000?
That is para 3 leadership.
Para 3. Yes.
If I may please.
Yes.
It has been alleged in the 4th paragraph of the show cause notice that some amount has been donated to the Confederation of Central Government Employees and Workers to provide help to farmers movement. Our federation is an affiliate of the Confederation and contributes to the fund as quota of the Confederation each year. It was a usual contribution that has been made to the Confederation and accordingly noted in the account of NFPE. Later on, the Confederation has intimated that the fund was utilized for the aid of farmers. Thus, the utilization of the collected fund was a decision of the Confederation and was not under the control of our federation. The aid was provided to the farmers' movement by the Confederation. Our federation decided to remain transparent by letting our members know how the fund was utilized. In one of the subsequent meetings, the matter was informed to the federal executive members, and in November 2022, it was reported before the House of Federal Council, and the delegates have approved it. It has been noted in the minutes and submitted to the Directorate also along with 2 amendments of the Constitution, which has been approved by the department without raising any objection. So the allegation that our federation made donation to the farmers movement is a distorted fact to serve the intention of the complainant. However, in general, it also needs to be made clear that our federation has a glory of contributing on many occasions for the cause of humanity. like we have donated in flood, earthquake, storms, and that had put our nation and citizens under grief and need. We would like to invite your kind attention to clause 4E of the Constitution of NFPE, where we have obligated ourselves to work for the interest of the nation. It is known to all of us that the government of India took a soft stand on the demands of the farmers movement, and it was clinched amicably. Had it been against the interest of the nation, it would not be accepted by the
You
government
see,
of India.
if this fund was for against some quota, why was it required to be explained by you, or why was it required to be reported to you that it has been used? Are they supposed to give any utilization report to that? If
Not
it is
that
against a quota, they are not required to give you any utilization report. And this quota is not a fixed amount. As per the rules which you have annexed, this quota is only for the purposes of some kind of function which takes place.
Leadership.
Yes.
So if I may indicate leadership, quota.
There was no ensuing function where it has to be taken care of. And even post facto sanction of this kind of payment, how could you do it? You should have asked for the refund.
Leadership quota.
This is a post facto, and you amend your rules also. Which rules did you amend?
Leadership, that was not relevant in this
I do
particular
not know.
incident.
You are
Leadership.
referring to an explanation by saying
Leadership
that the
in
rules
which-
were amended.
Leadership, it is just for stating that the rules were amended in that particular meeting wherein this particular transaction was discussed, leadership.
Yes.
It was completely different, leadership. It had no bearing on the instant scenario that was going on.
So you as an association
Leadership.
approve of this, maybe post facto.
Leadership.
You as an association approve of this funding. Correct?
Leadership.
Yes. Now you tell us from your regulations,
Leadership.
it only says that the amount has to be used
Leadership.
only for the purposes of the members.
Leadership, the rules, if we may come to the rules again.
No, you come to the rules.
Leadership.
Utilization.
Leadership, rule 5H, which talk about utilization. It is at page number 46, leadership, of my written petition.
No, we will read this rule, whatever you have annexed. Bylaws.
Bylaws.
Yes, you come to the bylaws. Annexure 20, page 4.
Yes.
Aims and objects,
Objects.
right?
Leadership.
To render efficient service to the nation,
Nation
and the people. So you are talking about which service? Postal service.
Leadership, this is a very broad categorization, leadership, to service the efficient render efficient service to the nation and the people, leadership.
Yes.
The context in which leadership the said amount was paid. Leadership, it was only to provide aid to the farmers who were lying without any shelter and without any food on the streets, leadership. It was not to further cause any harm to the nation. It was only to provide.
We do not know what was it utilized for, nor you were aware what was it utilized
leadership
for.
when it was intimated.
What intimation? Intimation was for farmers movement, and that's all.
Yes, leadership.
So,
and leadership, that amount which was given, it was only to improve their lives so that they don't die out of hunger or out of any elements of nature, leadership. That was the sole purpose for which the amount was
We do
given,
not
and it
know.
was only a token amount of solidarity, leadership.
why didn't you? The point is,
Leadership.
that is not the aim and objects of your organization.
It was made in furtherance of that aim, leadership, that to render efficient service to the people at large. And seeing the sufferings of the people, leadership, it was only for that the Confederation went on to donate that amount.
You just see clause 10.
Leadership.
The funds of the union shall be applicable for the purposes of, read it please. The utilization of fund, whether this utilization is as per clause 10. Application of fund, right?
Leadership.
Read it.
Leadership. All the clauses, leadership.
Yes, of course.
Payment of
and
salary.
bring home under which clause you are.
Leadership, 10G, leadership.
10G.
Payments in furtherance of any of the aims and objects of the union on which the general funds may be spent.
General fund is to be spent under which head?
Leadership.
General fund.
Leadership, it is. The said payment was made in furtherance of the aims and objects, which has been like application of funds. 10G states that payments can be made in furtherance of the aims and objects of the union. And these are the general funds, leadership, from which the said amount was given.
You come to 33 Roman 5.
Leadership.
Yes, read it.
Financial Secretary. He shall be personally responsible for the funds of the union and records pertaining thereto. He shall receive contributions and all dues from the branch/divisional unions and grant receipts in printed forms for all amounts received by him. He shall make payments after getting the vouchers attested by the circle secretary and maintain vouchers for all the payments made. He shall maintain day books and other account books and place the accounts every month before the circle secretary for scrutiny, approval and signature. The accounts shall be maintained in a manner to show separate heads for the income and expenditure as required in the statement to be submitted to the registrar of trade unions and to the auditor. Leadership, this is with respect to the circle union. Maybe seen it is under the heading Part 3 Circle Union. The circle union leadership exists at every state. For example, leadership, the present petitioner is a circle secretary of Jharkhand circle. This financial secretary is office bearer of the circle union leadership. With respect to each circle.
So the transaction is from the circle only?
It was made from AIPU general funds leadership, not from any circle leadership.
General fund is a common fund for the entire
Leadership, so All India Postal Employees Union Group C, it is at the national level, and branching downwards leadership, their same association has unions at circle level as well as levels which are lower to circle level as well. So the said transaction leadership was made from the general funds of the union, not from any circle fund leadership.
You have paragraph 53 also, similar. The point is, you see, you tried to justify this remittance by saying that you had remitted it against the quota,
Leadership.
right? If you had remitted it against a quota,
Leadership.
then under such circumstances, where was the requirement to have a utilization of this particular amount by whomsoever you had paid?
Leadership.
If it was for a quota, it was simply for a quota.
Leadership.
Simple. The moment the utilization comes,
Leadership.
it means that there is a diversion of fund, which was it means that though you paid it for a quota,
Leadership.
but they have diverted it.
Leadership.
You have not objected to it.
No leadership.
You have confirmed the payment
Leadership.
and confirmed it under a different head altogether. You
Leadership.
see, initially you say it is for quota. That is under head A.
Leadership.
Correct?
Leadership.
Then you get a utilization report, and the utilization report says that it is for head B. You don't object to it. You approve of it. How the remittance made under head A
Leadership.
can be utilized and confirmed subsequently under head B?
Leadership, when it was informed by the confederation, leadership that we
You
said,
never objected.
leadership, because it was decided in the meeting.
What meeting? That is why cancellation. That is why cancellation. Your explanation to this particular remittance
Leadership.
is absolutely not acceptable.
Leadership, on this note, if I may also indicate.
It is something like, you send somebody to buy oranges,
Leadership.
right? For that particular quota, you make payment. And then he buys something else, he gives you an utilization report, and then you confirm it. It means what? You cannot, your explanation, I could have understood that you had given them some money out of some fund and they utilized it in that manner. And you had no idea for which they are utilizing. That is not the case here. That is not your explanation.
Leadership, if I may also indicate, the explanation, leadership, herein what has been given is for NFPE. This particular explanation throughout in paragraph 3.
We do not know who is explaining. It is your explanation. You give a joint explanation. You are hand in gloves with each other. What else is required to demonstrate this?
Leadership.
You have not made any allegation that you did not pay this amount and
leadership,
they have misutilized it.
Leadership.
That is not your case.
Leadership.
So,
If I may also indicate.
farmers' movement is for public good. How
Leadership,
did you dream of it?
Leadership, the 3 acts that they were protesting against, if I may place leadership.
We don't bother about it. This kind of protest, taking the entire nation for a ransom, Continues even today.
Leadership, this was
You are
for
still funding it?
no leadership.
Why not? You should fund it. It is as per your rules
Leadership,
and
the
regulations.
agitation that was being
You
carried out
should
earlier.
divert your entire fund to them, whatever is there.
Leadership, it was only a token amount of solidarity.
Token,
Leadership.
what solidarity?
If leadership
Token
at
amount.
that point of time, leadership, their stance was against the 3 laws by which leadership each and every citizen was going to be impacted if they would have come in place. Leadership. That was the stand that was being taken by the farmers at that point of time. It was only in solidarity to that.
That was in anticipation of 3 acts.
No, leadership. The 3 acts had been passed. The bills had been placed. Thereafter, the Supreme Court went on to stay the said acts. Leadership. Leadership, if I may also indicate, leadership, herein the allegations that had been leveled against us.
These acts were passed by that time.
No, leadership.
Then?
The Supreme Court had stayed leadership. There was a stay granted by the Honorable Supreme Court, and thereafter the said acts were withdrawn by the Government of India.
You see, subsequent confirmation of utilization of this fund
Leadership.
is sufficient to not grant the relief to you. You approve of it. This cannot come within the this rule. What do you say?
93. TCS has its rules.
This will not come. Nor as per your bylaws also, to render efficient service to the nation and the people. This is essentially for your postal services. This is not for, you collect money from the people and keep on spending.
Leadership, to render efficient service, leadership, prior to this incident as well, leadership.
No.
Because leadership, this connotes a very wide spectrum of
We
beneficial
will
services.
interpret it, don't worry about it.
Leadership.
We'll deal with it.
If we may come to the another allegation, leadership, that was of providing rupees 50,000 to CITU. Leadership, on that note, not even, no evidence has been placed, nothing has been brought on record, leadership, to show that any amount was ever given to CITU, which has been categorically denied by us throughout.
In the reply, what has been you have denied that transaction.
Yes,
completely. In the impugned order, what is the impact of that?
Leadership. 7.2 leadership.
7.2.
Leadership.
This is 30,000. 7.2, yes.
Yes, leadership. They say the submission of associations that the transaction of rupees 4935 was a personal transaction, which was erroneously paid from the association's account, holds no legs to stand on and are mere afterthoughts. The association has not provided any evidence in this regard, since how a personal transaction can be made from the account of association. Further, in case any transaction is made from the account of association/federation, it will be considered as collective decision of federation. Further, as per copy of bank transaction, it was evident that bank transaction of rupees 50,000 from account of association to account of C2. Leadership, we have never received any such copy of bank transaction, neither do we have a copy of such bank transaction, even at the stage of
Where have you stated that there is no such transaction?
Leadership. Now, reply may be seen, leadership. Paragraph 4. Page number 63, leadership.
Yes.
It has been alleged that rupees 50,000 only has been donated to CITU. We found that this allegation is concocted, absolutely baseless and false. This reveals the true intention behind the complaint. NFPE and AIPU Group C are not even affiliated to CITU since the beginning in 1954, and then NFPE since 1985, and maintained its distance from all trade union wings of political parties. There is no question of making any donation to CITU, therefore allegation of funding trade union wing of a political party and violation of CCSRSA rules 1993 is denied.
So there is no evidence to that effect, there is no transaction.
Leadership.
They have not referred to any particular date of the
No
transaction.
leadership. Leadership.
That's all on merits.
If I may indicate, leadership, for all the 3 allegations, it was all based on a complaint, leadership. So it is apparent from the records itself. Leadership, throughout entirety, no
You don't
evidence,
need to
no,
see the complaint.
nothing whatsoever
You see,
has been
ultimately
presented
the
to us,
complaint
leadership.
culminated into a show
Show cause
cause.
notice,
So
leadership.
we are only concerned with the show cause.
Leadership. On
We are
this,
not bothered about
leadership.
the rest.
Leadership.
That's all.
Leadership. If I'm on this submission, leadership, I have a judgment which I seek to refer to, leadership. It is State of Odisha versus Binapali D and others. It is 1967, SCC Online, SC 15, leadership.
Online page
SC 15, Supreme Court 15, leadership.
50
15, leadership.
One.
I've provided a copy of all the judgments, leadership.
Bina Pan, right?
Yes, leadership.
That if there are 3 reasons,
Leadership.
I remember having read this document long back.
I only seek to present, leadership, the position that was laid down in this landmark judgment, leadership, which is at para 12,
We'll continue in the second half.
leadership.
You were given sufficient opportunity. You are looking for what?
Leadership evidences that they have referred to in their final order as well. Throughout the entirety, leadership, no evidence has been
You see,
given to
2
us. which we
transactions
could-
are admitted.
Leadership.
30,000 is admitted.
Leadership. Leadership.
4,000 is also admitted.
Leadership.
Now, third transaction is in
Leadership.
dispute, right?
Leadership.
That's all.
On that note, leadership, no evidence was given.
Forget it. We'll say that there is no evidence to that.
Leadership.
Because you have said that there is no evidence. They have not brought anything
No,
on
that
record.
so
also.
far a 50,000 that will appear from the bank account, that has been mentioned in the agreement.
We'll see that.